Before we get to our presentation, I'm going to ask, we're going to do some introductions. We're going to start with the pages. So if you could tell us your name, where you go to school, and anything you'd like about, we'd like to welcome you.
Hi, my name is Melanie Carpenter. I'm from Rockbridge County, and I go to school at Perry McClure.
Hi, I'm Flora Wiley. I go to Village School, and I'm from Charlottesville.
Okay, thank you for being here to assist us. Now we're going to just have the members briefly introduce themselves. Let's start on this end. If you could, senators, just introduce themselves, where they're from.
Yes, hi, I'm Senator Christy New Craig. I represent Senate District 19, which encompasses parts of the city of Chesapeake and the city of Virginia Beach.
Hi, my name is Timmy French. I represent Senate District 1, which is the northernmost part of Virginia, which is Shenandoah County, Frederick County, Sandy, Winchester, Clark County, and Warren County.
Hi, I'm Emily Jordan. I represent the 17th District, and I represent parts of Portsmouth, Chesapeake, and Dinwiddie, and the whole localities of Suffolk, Isle of Wight, Franklin, Southampton, Greensville, Brunswick, and Emporia.
I'm Chris Head, represent Senate District 3, which is part of Roanoke County, and then all of Botetourt, Craig, Allegheny, Rockbridge, and about 25% of Augusta County, and also the independent cities of Covington, Buena Vista, Stanton, and Waynesboro.
Todd Pillion, Senate District 6, Lee Scott, Wise, Washington, Dickinson, Russell, Buchanan, and the cities of Norton and Bristol.
Jeremy McPike, 29th District, representing parts of Prince William County, town of Dumfries, and North Stafford.
Adam Eben, representing City of Alexandria, as well as parts of Arlington and Fairfax.
Good afternoon, Mamie Locke, representing the 23rd Senate District, which is all of the city of Hampton and part of the city of Newport News.
Good afternoon, Senator Rouse, representing District 22, that is City of Virginia Beach.
Good afternoon, Skylar Van Valkenburg, representing the 16th District, which is Western Henrico County.
Hello, my name is Stana Carome. I represent the 30th District, which includes the City of Manassas Park, and Western Prince William County, including the town of Haymarket.
Good afternoon. I am Angela Williams-Graves, representing the 21st Senatorial District in the Commonwealth, and that is the majority of the city of Norfolk.
Thank you. And we're going to have a presentation, but before we do, I just want to do a little bit of housekeeping in case people are waiting on these particular bills. There were two bills that the patrons requested go by for the day. Those are Senate Bill 985 from Senator Williams-Graves and Senate Bill 962 from Senator Carol Foy. Do I have a motion to pass those by for the day? Okay, and a second. All in favor of them going by for the day will say aye. Aye. Any opposed? Okay, those bills go by for the day. I had a request of the patron that Senate Bill 809 be stricken. That's a recorded vote, right? Okay, so we'll need to have a recorded vote on striking Senate Bill 809.
Ayes 13, no 0.
Okay, so that is stricken from the docket. Then there's some re-referrals. Can those be done in a block, or do they have to be voted individually?
We could do the judiciaries together.
Okay. So there are several bills that need to be re-referred to other committees. The first was Senate Bill 815 and Senate Bill 1221 to courts of justice. Is there a motion to do so? Okay, it's been moved and seconded. All in favor, please signify by saying aye. Aye. Oh, recorded vote. Okay. Please indicate on the voting board.
Ayes 15, no 0.
Thank you. Then Senate Bill 1164, which I believe was from Senator McDougal, goes to Finance. Is there a motion and a second to?
Second.
Okay, so all in favor of sending? Yeah, Senate Bill 1164 will go straight to Finance. So let's open the vote on that.
Ayes 15, no zero.
Thank you. Then Senate Bill 1178 will, is there a motion to re-refer that to local government?
So moved.
Second.
Okay, all in favor, please indicate your preference on the voting board.
Ayes 15, no zero.
Okay, that is re-referred. And then there's Senate Bill 1190 to re-refer that to Commerce and Labor, Senator Deeds' bill.
So moved.
Second.
Okay, there's a motion, a second, so let's indicate our preference on the voting board. And that motion passes unanimously? Okay. And then last re-referral is Senate Bill 1251 to Rehab and Social Services. Is there a motion?
So moved.
Second.
Okay. All in favor, please indicate on the voting board.
Ayes 15, no zero.
Okay, and then I have a number of bills that we're going to refer to the gaming subcommittee. Does that require any kind of motion or just an announcement? I'm just going to announce that. So listen carefully because there's 12 of these bills. I know there's some people interested in a casino proposal, and this bill is included amongst them. The following bills will be considered by the gaming subcommittee, and those are SB 863, SB 889, SB 864, SB 827, SB 862, Senate Bill 982, Senate Bill 1223, Senate Bill 1241, Senate Bill 1245, Senate Bill 1287, Senate Bill 1280, and lastly, Senate Bill 1315 will all go to the gaming subcommittee. The gaming subcommittee is chaired by Senator McPike, and its membership includes Senator Locke, Senator Reeves, Senator Pillion, Senator Head, Senator von Valkenburg, and Senator Carol Foy, and I serve as an ex officio member. So that's where testimony will be taken on the bill that you all are interested in. So I would pay attention for that because when the bill comes to the full committee, if we take testimony in the subcommittee, we're not going to re-hear testimony in the full committee. And there won't be virtual testimony for the subcommittee. So pay attention for announcements on when that subcommittee meets. And I think the next order of business is our presentation from Colin Hood, who's the director of Guidehouse. He's going to present, he's been consulting with the committee to study the feasibility of establishing a gaming authority or agency for the Commonwealth to consider all kinds of gaming. And I'll turn it over to Colin and thank him for his work over the past year or 6 months or so on a gaming commission.
Great. Thank you, Mr. Chair, members of the committee. Thank you for the opportunity to come today and share some of the findings and insights that came out of our work. As the chair mentioned, we were contracted by the Division of Legislative Services about 8 months or so ago to begin a study on the feasibility of the Virginia Gaming Commission. The core question that we were asked to answer, is it feasible to stand up a gaming commission? What are the benefits? What are the costs? And to determine a succinct list of recommendations for ultimately the joint subcommittee to consider, and then of course to bring on to groups like this. So today I do want to be brief. It certainly was an extensive effort. I want to highlight some of those recommendations and leave any time for questions that you all might have. We'd be happy to answer those today. As the chair mentioned, my name is Colin Hood. I'm a director in Guidehouse's state and local government business. We are about 18,000 management and technology consultants headquartered here in Virginia. So we're always excited to have an opportunity to support projects back here at home. Doing operating model design is certainly one of our core capabilities. And in addition to our team, we had very close collaboration with a handful of agencies that I believe deserve recognition. We're very appreciative of the time they put into the effort, and that ranges from the Virginia Lottery, VDAX, the Virginia Racing Commission, Department of Accounts, DHRM, Tax, VITA, DLS, JLARC, DPB, the Virginia State Police, Behavioral Health, the Problem Gambling Council, and several others. So I just want to thank them for the time that they put into the data collection and helping us come up with the models and the recommendations you all will see today. Some history on the effort. This effort initially began with a JLARC report, which asked the question for further investigation into what a model may look like. There were bills establishing a joint subcommittee to study the feasibility. Our effort began, it was led with both benchmarking and a cost-benefit analysis report that we shared last year with the joint subcommittee. And after additional analysis and work, leaving that group with a set of recommendations that I'll highlight today. The Joint Subcommittee did vote to adopt those 13 recommendations, and we'll share those results during this discussion. Just a little bit of preview on the current gaming landscape in Virginia, and this data is dated from when we initially shared it last year with the Joint Subcommittee. A few takeaways as you look at the total handle across Virginia. And as I mentioned, there's important dates to recognize as these figures certainly have continued to change since this slide was initially put together. There's different reporting periods, there's different reporting requirements, there's different access to this data across the different gaming types. The total handle looks very different today than where it looked 10 years ago and what it will look like in the future. I think the takeaway from this slide is that it's an evolving landscape. It will continue to evolve, and the needs of the Commonwealth to regulate these industries will certainly rise. So as we looked at standing up a new gaming commission and its feasibility, one of the lenses that we applied was certainly cost. What's the most effective way for the Commonwealth to manage the growing demand of regulatory pressure on these different gaming types? And we'll speak about that today. This is not a challenge unique to Virginia. States across the country are trying to figure this out. A couple of them have stood up consolidating gaming commissions, but most states are asking themselves the same question the Commonwealth is, which is how should they adjust their posture to handle these new emerging regulatory needs? We did answer the question with a definitive yes around the feasibility of standing up a Virginia Gaming Commission. There's certainly one-time costs with standing up any new consolidated model, but we believe those costs will be realized and mitigated over the long term and the savings that the Commonwealth will realize by having a consolidated model compared to the fragmented model that exists today. We think there's a lot of benefits to a consolidated model that position you all to have not only a stronger and better positioned regulator, but also to fill many of the gaps that you all have in the current landscape today. Gaps both to the legislature as you all make policy decisions, but to your local and state agency partners who are trying to implement the regulations set by this body, including local law enforcement. Today, without a Virginia Gaming Commission, there is not a body to respond to new regulatory and oversight needs from, whether it be in emerging gaming types or changing conditions and industry trends for the gaming types already adopted by the Commonwealth. There's not a body that's there to help support and maintain the Commonwealth's commitment to the horse racing and charitable gaming industries. Certainly today, there's dedicated, hardworking teams of public servants focused on horse racing and charitable gaming. But in a fragmented culture and fragmented landscape, they're not there together to help support the analysis and to support this body as you all consider new gaming types in the future. A gaming commission's best positioned to capture long-term forecasted economies of scale. I'm going to show you all a concept. You'll see some of the similarities in the functions when it comes to regulating gaming, from licensing to auditing and compliance. And these are core operational savings that you all will realize over the long term. Increased transparency through centralized annual reporting to the public, and certainly increasing the consistent accountability for gaming regulation and oversight. In today's fragmented operating model, there aren't frameworks for that consistency, and you all are not receiving consolidated, consistent reporting. In today's environment, there's not a group dedicated to facilitating a consistent statewide problem gambling strategy. There's certainly dedicated resources from a clinical stance and other stances when it comes to problem gambling. But this group would fill that void, and we'll show you all a concept of that in a moment. And I think importantly, clarifying the points of contact for key stakeholders. And that ranges from the Virginia State Police, local law enforcement, legislators, players, members of the industry community. Today, when there's a question on a gaming type, on a regulatory matter related to gaming, there's not a single point of contact or a centralized source of information available to solve those challenges. We left the committee with 13 recommendations, and I have visuals and additional information on any of these in which you all have questions. We did recommend consolidating all gaming regulatory and oversight operations in the Commonwealth, with the exception of the Virginia Lottery, and I'll mention that in a moment, into an independent, centralized Virginia Gaming Commission. We also recommended structuring the Virginia Gaming Commission to maximize forecasted economies of scale, facilitate cross-training, and leverage best practices within similar functions across those different gaming types. We recommend creating the Virginia Gaming Commission Board and assigning it regulatory and oversight responsibilities over all gaming types with the exception of the lottery. And this does not include the non-gaming matters related to live horse racing, which I'll mention in a moment. You've heard me mention several times about the lottery. We do believe the lottery is a very productive, successful organization focused on operationalizing and administering the Commonwealth's gaming type, which is the lottery and certainly the related iLottery products that they have today. We believe that it's in the Commonwealth's best interest to focus on standing up a regulatory body dedicated to the regulatory component, and then consider, as I'll mention in a moment, a longer-term consolidation in the future. Number 4, we recommend maintaining the Virginia Racing Commission, the board, and transferring HHR, ADW, and other related gaming types when it comes to live horse racing to the Virginia Gaming Commission. Number 5, directing the Charitable Gaming Board, a really important group currently supporting VDACs today, which we believe should support the new VGC in the future, to advise the VGC on all aspects on the conduct of charitable gaming in Virginia. That's a diverse and large stakeholder group, and it's critical to the Virginia Gaming Commission being successful in the future. Number 6, establishing a problem gambling division in the Virginia Gaming Commission that could coordinate with local, state, and national stakeholders to manage problem gambling research, prevention, recovery, and treatment efforts. This is not a duplicative function in state government today. This is an addition that fills an existing gap. Number 7, establishing an external affairs and policy division in the Virginia Gaming Commission to recommend gaming policy decisions to legislators and communicate with relevant stakeholders in Virginia. As you all think about related decisions, the current gap today is an organization within government that can generate the data, the policy analysis, and the other insights you all need to make those decisions. It's the intent of the Virginia Gaming Commission team noted in number 7 to fill that void. Number 8 is establish an executive leadership team in the Virginia Gaming Commission and define the roles and responsibilities with a clear division of duties, including elevating the role of the Executive Secretary of Racing. I mentioned earlier the importance of the commitment that the Commonwealth has to both racing and also to charitable gaming. By elevating the role of Executive Secretary of Racing and bringing them to the table for other gaming type decisions, including being an ex officio member of the Virginia Gaming Commission. The intent is to elevate racing and for the Gaming Commission to have a full understanding on the impact on its existing commitments to gaming types before making recommendations on emerging gaming types. Number 9, maintaining the existing beneficiaries of revenue stream from each gaming type. Today, there's a diverse list of beneficiaries. For example, HHR revenue continuing to support the live horse racing industry, and this model can sustain and should sustain those beneficiaries. Number 10, directing the Virginia Gaming Commission to review consolidating technology systems to increase the efficiency of core functions. Number 11, directing the VGC to develop a standardized approach for reporting to the General Assembly on a regular basis across all gaming types. This is a void in today's landscape, and without a gaming commission, there's no clear agency to take on this task. Number 12, following implementation of the VGC, consider how to further invest in gaming enforcement. And then number 13, following the successful launch of the VGC, reconsider lottery operations consolidation in the future. As I mentioned, we think it's important with any change or merger of this type to not impact current productivity or risk profit that the Commonwealth is benefiting from today. So we often recommend a phased approach of this type. Focus on filling the immediate need, which is a gap in regulatory oversight over new gaming types and some existing gaming types, and then reconsidering a broader consolidation in the future. I did want to preview one graphic, and as I mentioned, I've got several visuals for any questions that you all may have. What I'm showing you is a concept of what a Virginia Gaming Commission may look like. The word concept, I think, is really critical here. Is this certainly would be evolved in collaboration with the agencies involved in transferring into this new organization. Once you move from a concept into a true org chart, there's other considerations at play, including the skill sets and the capabilities of the leaders that are ultimately selected for these slots. But I do think it's a helpful concept to understand how there's benefits to the Commonwealth for considering cross-trained teams across some of these core functions, which should result in an improved experience for charities, industry players, and other stakeholders impacted by these gaming types, and demonstrate how over time this is a cost-effective way for the Commonwealth to manage this regulatory function. Continuing to piecemeal each gaming type as it comes in and build separate organizations certainly is a more expansive organizational chart that would miss opportunities for synergies and to leverage existing knowledge and resources of the Commonwealth's ecosystem. Okay. Mr. Chair, at this time, I'd be happy to take any questions.
Are there questions from members of the committee about the recommendations in the report and the research? Senator?
Chairman, if I could ask, so you're saying that Virginia Lottery would stand on its own in the beginning, but later down the road, it would be recommended to incorporate it underneath the same commission?
Mr. Chairman, we have recommended for another analysis and consideration to be made. At this time, it's unclear of the benefits of that in the future. I think some states are going in that direction. But when how we think about a lottery, which is an organization that, in order to be successful, needs an entrepreneurial culture, focusing on marketing, compliance, and the core administration and operations of a lottery, it is a different skill set than an agency focused on regulatory functions. So in our minds, when we think about the pace of change, we think it's important to focus on the current need, which is to stand up that regulatory agency. But I do think it's of note in a time period at, we'll say roughly maybe 5 years, to relook at this, look at the current gaming landscape and think, is it worth it at that time? Do the benefits outweigh the costs?
Thank you. Next in the queue, we've got Senator Rouse.
Thank you, Colin, for the presentation.
Of course.
My question revolves around, this will be an independent organization, correct?
Yes, sir.
So will it have an independent enforcement? Who would handle the enforcement on this?
Yes, sir. So in our current model, and I'll pull the visual.
And perhaps I missed that in the presentation.
It's a great question, sir. And we address it at number 12. At this stage, we believe that the actual gaming enforcement division is something that should be reconsidered in the future. Some states are looking at that model today. And when we think about enforcement, we think about this organization focused much more on compliance. In today's ecosystem, local law enforcement and the Virginia State Police and others focus on the enforcement lens compared to the compliance lens. And that's how we envision this model. I do think by standing up a consolidated organization, you open the opportunity to consider centralized enforcement arms. And whether that be a set of special prosecutors, whether that be a unique law enforcement agency, those are options in the future. But at this time, our core focus has been on compliance and a continued partnership with local and other law enforcement organizations.
Mr. Chairman, a follow-up?
Yeah. Please follow up, Senator.
And so on the enforcement piece, if somehow compliance or if there is an altercation or something, will that fall up to the local enforcement agencies to enforce or safely protect the whatever gambling establishment, if you will? Or is there, how does that work? Or would it be state police? I'm just trying to understand if, as you set this up, will there be a different enforcement if you will, wing that would just handle compliance, but yet partners with the local local law enforcement agency to carry out the protection of the gaming institutions.
Yeah, yes, sir. It's a great follow-up question. In today's environment, there is an Office of Gaming Enforcement in the state police that fills some of that coordination role. And we do believe, and we've included it on this concept because we wanted to reinforce the importance of that continued coordination. In this model, the enforcement mechanisms would continue to remain the same they are today, and those do vary per regulation, gaming type, just depending on the existing statute.
Thank you. Any other members with questions? Colin? Okay. Thank you for all the work that guys did on this, and for your efforts and for being here today. That presentation, do we have that presentation to distribute to members of the committee?
You do, yes, sir.
Okay, good. I'd ask the clerk if you could to email that to all the members of the committee so that everyone, particularly members of the gaming subcommittee, will have access to it. Thank you.
Thank you for the opportunity.
Okay, good to see you. Okay, the next part of agenda is we can go to our bills. I believe the first in the queue is Senator Durant. Could you tell us what bill number we've got first?
Good afternoon, Mr. Chair, member of this committee. I've got Senate Bill, I should know my bill numbers, 1282.
Okay, so we'll direct our attention to Senate Bill 1282 and to Senator Durant.
Yeah. Just a summary of this, the federal government is transitioning from the current National Fire Incident Reporting System and NFIRS, I think they call it, to the National Emergency Response Information System, NARIS. And in Virginia, there are about 2/3 of localities use the NFIRS right now, and so that makes it a little bit challenging for the state to get data-driven decisions about fire service. And so localities receive what's called aid to localities, ATL funds, annually based on population. And this bill would require localities to report to NARIS to receive those ATL funds. The bill would improve data-driven decisions on the state, local, state, and federal levels. And I just want to report, I've been working with the House patron, Delegate Josh Thomas, on this bill, who's carrying the cognate. When I first took a look at this bill, I did give a call to my local fire chiefs that are in my district and spoke with some of the folks from the state level, and they were all comfortable with it. The one thing that they did ask is that we would consider the delayed enactment. So we have included that to give everyone a chance to make sure they get caught up on that, and that would give them an opportunity to get that transition. And also, I think it's important to note that there is grant money that localities can access to get their reporting systems in, so that they've got kind of that infrastructure in place to get them in line, so we can get that data streamlined in compliance with the federal law. So happy to answer any questions. I do have a couple of folks from the fire that are here to answer as well.
Thank you. Are there questions for Senator Durant on this bill? Okay. Are there those in the audience who are opposed, who want to express opposition to this bill? Okay, so seeing no opposition, is there anyone who wants to speak briefly, perhaps, in support?
Those online who would like to speak to the bill, please raise your hand.
Mr. Chair, Spencer Willett, Department of Fire Programs and with Secretary of Public Safety. We want to thank the Senator for carrying the bill. This changeover in the federal system is the perfect time to do this. The nearest system should be able to give us data much more quickly. And so by requiring localities to share that information with us, we should be able to provide that to policymakers and to other state level leadership in making those decisions of where funding should be. There's been a couple reports in the past few years to the General Assembly on some significant funding issues in the fire service, but one thing we can't provide you currently is where these fire incidents are occurring because of the lack of data.
And can I ask, is it pretty easy to comply to report? I mean, is it an electronic system that is that most fire departments already have, or that they can get easily?
Mr. Chair, to answer your question, the former system that's going out of practice is about 30 years old, and it's pretty burdensome. The new nearest system that will go into effect this year from FEMA is expected to be as easy as a smartphone app that someone should be able to do on their phone. Most localities use a third-party system that they pay for, but it's not a requirement.
Thank you. And was there anyone else or anyone on the line who wanted to express comment? Okay. Is there a motion? There's a motion and a second to report, and this bill does not need to go to, the finance has not requested it. So we can open the vote. Please express your preference on the electronic voting board.
Ayes 15, no zero.
Okay, thank you, Senator. Do you have another bill?
No, sir, thank you.
Okay.
Thank you very much, members of the committee.
Sure. Next is Senator Hackworth. If you could come forward and tell us your bill number.
Thank you, Mr. Chair, members of the committee. I have Senate Bill 1248.
Finance.
Okay.
I have a substitute I need to move.
Okay, there's a substitute for this bill. Does someone have one that they could pass to members of the committee? Why don't you, the substitute has been moved and seconded. All in favor of adopting the substitute, please say aye.
Aye.
Any opposed? Okay, so the substitute is before us. If you could tell us about the bill, particularly any significant differences in the substitute from the original?
Yes, sir, Mr. Chair. So this was brought to me by request from one of our local towns, the town of Burke's Garden, or community of Burke's Garden. And they are firefighters that are trained to do fireworks. And they found out under the current code that they must pay a $300 permit fee and $95 an hour to pay for on-site state fire marshal to come and inspect. And then there's different varying processes they have to go through. So they ask us if we could run this bill that would basically say that a locality with a total population of less than 10,000 people, that they could waive that fee so that they could provide the fireworks, been licensed to do so. The substitute, we met with the state fire marshal, and they said that they did not have a problem with it as written in the substitute that basically says the approval and administration permit issued pursuant to Code Section 27-97.2 to a fire department as defined or an emergency medical services agency as defined, serving a locality with a total population of less than 10,000. I think they said during the records they researched, there was only one such permit that they had issued last year that this would have impacted. So we have them here, I think, if they would like to speak on that, but that is the bill, Mr. Chairman.
And if there's a fireworks display in a locality, a smaller locality, would they still be inspecting and supervising?
Yes, they would still come and inspect.
But not charging?
They would not charge, correct.
And they'd be charging every other?
If you have a population of over 10,000.
I see.
Yes.
Okay. Maybe it would be good for the fire marshal office to come forward.
Mr. Chair, Spencer Willett, Department of Fire Programs in the State Fire Marshal's Office. So we did work with the Senator earlier today on amending this. We don't issue a large amount of permits in localities that have under 10,000. We do have this issue with small fire departments that are using these shows as a fundraiser for themselves. And so with the amended language, we see we have no opposition to the bill.
And with the amended language, would you be required to engage state personnel to be present at these sites? So we'd be doing it gratis and still incurring some staff time or?
Mr. Chair, we would still be present to issue the permit, so we always do a pre-inspection of the facility and then usually a post. On some shows, depending on the size, we have someone there the whole time. But for most of the shows that would be affected by this, by fire departments doing these shows, they're small enough where we wouldn't have someone there the whole time. So we would still be doing it, still be issuing the permit, just not charging a fee any longer.
Okay. Are there members of the panel with questions for either the fire marshal or for Senator Hackworth? Okay. Is there anyone here who's in opposition to this bill?
Those online who wish to oppose, please raise your hand.
In the audience, anyone else who'd like to express support for the bill briefly? Okay.
We refer to finance.
Yeah, the motion from Senator Rome is to report, and we refer to finance, and that's been seconded. We will now vote on Senate Bill 1248 substitute.
Ayes 15, no zero.
Okay, thank you, Senator Hackworth. Was that that was your only bill today, right?
It is.
Okay, thank you.
Thank you, Mr. Chair, members.
Next on a list, I've got Senator Williams Graves. Is she in the audience?
She just went to court.
Oh, she's on our, on our committee and in courts for a moment. So let's go to Senator Pekarsky. This is Senate Bill 1210. Is that right, or is there more than one?
Mr. Chair, there's also a substitute, SB 1210.
Okay. Is there a motion to adopt a committee substitute? Okay, it's been moved and seconded, so all in favor of adopting the substitute, please say aye. Aye. Any opposed? Okay. Senator, I understand this bill is a recommendation of the Housing Commission.
It is indeed.
Okay, and does the substitute reflect their final language, or?
It's the final language. It unfortunately had some drafting errors, but it is the final and approved language that you have before you from the Housing Commission.
Okay, why don't you describe the bill for us?
Sure. Thank you. This adds airport noise to the list of disclosures for purchasers of a residential property provided by the Real Estate Board. And as I'm sure you all are aware, Virginia is a buyer beware state when it comes to purchases of residential property. This bill would include a section in the required residential property disclosure statement that advises the purchaser to do their due diligence when determining whether the property they are purchasing is located near an airport noise overlay zone. To assist this, the bill also directs the Department of Aviation to make available airport aircraft noise zone maps that meet the FAA airport noise modeling criteria on its website. And this is, of course, an issue that is of utmost importance in my district because of Dulles International Airport. And as I continue to expand operations, prospective home buyers in Loudoun and Fairfax counties especially will be able to set expectations and understand that there will likely be an increase in aircraft noise occurring in these zones.
Okay, we had a bill last year that was more a little contentious that passed on a similar topic, but I understand this has been worked out among all the parties, that everyone agrees to it now?
Yes, sir.
Okay.
They have all come to an agreement, and I'm.
Mr. Chair, this is the same as the Realtors bill last year, or similar to that?
No. Last year, we had a bill that said that Senator Locke's bill said that you could not have a local disclosure required for one county about this topic. And this says that it's going to be added to all the language that you have to be aware, that buyer beware of aircraft noise or that sort of thing, right?
Yeah, Mr. Chair, so last year I think there was some disagreement as to how to make these disclosures, but the Virginia Realtors have been able to come together with others and through the commission come up with a workable result here, and that's what you have in front of you.
Thank you. Okay, I understand there's some folks who want to express their support for the bill. Is there anyone opposed to the bill? Okay, those in favor, if you want to just state your support and whatever else you think we need to know.
Good afternoon, Dave Alba, representing Metropolitan Washington Airports Authority, which is basically Dulles and Reagan National. I know enough when a bill comes out of Housing Commission unanimous and all the parties are in agreement not to talk a bill to death, so I'll be available for questions. But basically what this does is it puts on the buyer beware statute, heads up, you're going to buy a house near an airport. If you need more information, click on this link and it'll be a map, something like this, where you'd put your address in and would tell you what the noise criteria is. And for airports that don't have the map, it gives them information on how to get in touch with the Department of Aviation.
Thank you. Okay, and the Realtors would like to?
Thank you, Mr. Chair. Erin Corman with the Realtors. I'm not going to get into the details of the bill, but just wanted to thank the stakeholders for really working with us this summer and taking all of our members' concerns into account and coming out with this finished product. So thank you.
Mr. Chairman, Joe Lurch, representing VACO and also speaking on behalf of VML, and just want to thank all the stakeholders. We think this is a good path forward and support the bill. So thank you.
Move to report.
Okay, there's a motion and a second to report the substitute. Unless there's further discussion or questions, we can open the vote.
Ayes 15, no zero.
Thank you.
Great. Next, we've got Senator Favola. Is she here? Okay, she's in courts, so someone can tell her later, but Senator Perry, maybe when you go back to courts, you can tell Senator Favola to come on over.
I'm happy to do that.
We'll be there a while.
Does the chair have a preference in order of presentation?
Whichever you'd like.
Okay. I'll start with both of these bills come out of commissions, I think, with full support, unopposed from the commissions. I'm happy to start with SB 884.
Okay, so we'll direct our attention to Senate Bill 884.
This bill is an amendment to a previously existing bill that allowed for early termination of leases by victims of domestic abuse and sexual assault. The problem with the law as it stood was that typically if a protective order was issued or if someone was convicted of one of those types of crimes, you're often looking at several years down the road before we can get to trial, before we can get to a conviction in a serious case. Same thing with protective orders. Typically, in any criminal case, we allow those protective orders. We want, as a prosecutor, you would want those protective orders to trail behind the criminal case so that multiple people aren't testifying. You have, statements. It creates potentially evidentiary issues, and protective orders have a lower standard, so they're usually issued if a criminal conviction is found. The problem with that is the whole point of the bill is to allow victims to terminate their leases up front so they can get away from their abusers. And so it doesn't really do them a whole lot of good 2 years down the road to be able to terminate a lease that they probably were not in at the time of the offense when they needed to be able to escape and to hide. I also added in victims of human trafficking and victims of stalking in here as well to make sure we were covering some other people who may also be in the position where they need to go ahead and terminate their leases. I'm happy to take any questions from the panel about any of it.
Thank you. In the bill, you include also emergency protective orders, and is that essential to the what you're trying to accomplish?
Right. I included emergency protective orders and preliminary protective orders because those are the protective orders that are issued early on in the process. The permanent ones are the ones that are issued at the end of the process.
Okay. Before we hear from others, are there members of the panel with questions? Senator Reeves.
Thank you, Mr. Chairman. Senator, I'm just trying to read through this. One concern, and you can if it's in here somewhere and I just missed it. A victim of domestic violence, when you do let's say a permanent protective order and those sort of things, what proof does the victim have to present to the landlord that they are? Is it in here and I missed it? That they are a victim of it, and this allows them, kind of like military orders, right?
Mr. Chairman, Senator Reeves, that's part of the already existing code as it stands now. I believe it looks like they have to, let's see.
23.
I think it's subsection B, a tenant who qualifies to terminate such tenant's obligations under a rental agreement may do so by serving on the landlord notice of termination to be effective within 30 days. Also provide the landlord with a copy of the order of protection issued, conviction order, warrant, summons, information, or indictment. I think that's lines 38, 39, and 40.
Okay. Well, thank you, Mr. Chairman. Thank you.
Sure.
Why don't we see who in the audience, is there anyone who wants to express opposition or hesitation with the bill?
Those online who would wish to speak to the bill, please raise your hand.
Yeah, so if you're against or if the bill gives you pause, please come forward. Welcome.
Thank you, Mr. Chairman, members of the committee. My name is Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We would love to have a little more time to workshop this bill. We understand the intent. We do want to come to a support and protect victims, but we also want to make sure there's no potential misuse of changing the code like this, no operational challenges for housing providers on this end. Last session, we worked with Delegate Delaney on similar legislation, and we supported that to help victims of sexual assault. And we believe that the same collaborative approach would be great here. By focusing on preliminary protective orders, I think we can maintain that judicial oversight while allowing victims to get out swiftly. So we'd love to continue workshopping this bill, but as it is written right now, we'd have to oppose. Thank you.
Okay, did you raise any of those concerns in the Housing Commission that endorsed the bill, or?
Yes, we did raise this in the Housing Commission work group, and when it was referred, we were under the impression that it was going to continue being workshopped. And so I did support in that capacity.
Okay, thank you. Well, I think were there others? Will come forward, yeah.
Good afternoon, Mr. Chairman, members of the committee. Zach Lemaster with Gentry Lock Consulting here on behalf of the Northern Virginia Apartment Association, and I would just echo the comments of the previous speaker.
Is it fairly simple to improve the bill, or do you think it's something that, if in your eyes?
Yeah, I think certainly the argument or discussion regarding the temporary or the emergency protective orders is certainly something that I think is a big concern. There may be other speakers behind me that have additional concerns, but I know that's probably the top priority as far as concerns over the potential abuse of that system right there.
Thank you.
Thank you.
Senator Rouse has a question, I think.
A question for Senator Perry. Sure. You are attorney, correct?
I am.
What is the process like in securing a protection, order of protection, emergency order as well? Is that something, what is the level of evidence, if you will, if you need to get one of these? Is it easy just to go down and get one?
No, you have to, we went through this on the Housing Commission, and I'll tell the members that that the issue about the emergency protective order was raised. I had to go to 3 different meetings to get this to the Housing Commission, and so that issue was raised, and again, it came out unanimously. But to answer, Mr. Chairman, and to answer Senator Rouse's question, in other states, they have added additional things to these types of bills, which include, a doctor could provide a note essentially that says this person is a victim of one of these crimes, or your therapist could provide a note that you then provide to your landlord. I decided up front to pare it down because I was concerned it may not have the same level of protections, although I do understand many victims of these types of offenses don't go to the police, right? And I understand why those laws exist as well. But in this situation, an emergency protective order, preliminary protective order, both of those in a permanent protective order, both the emergency protective order, preliminary protective order, and permanent protective order, all 3 of those can be issued by a judge. Emergency protective orders and preliminary protective orders can also be issued by a magistrate, but they act in a judge position just like they do when they issue a warrant, just like they do when they issue a red flag order, just like they do when they issue a emergency custody order petition. You're going through those same people who have to present evidence. If you want a preliminary protective order, an emergency protective order, you have to write down what the reasons why you want it, and you have to sign it under oath, which then subjects you to the penalty of perjury, were you to lie or do something else that would not be truthful. And so it's my position that there are a number of things that protect from that abuse, and what this bill does most, the bill that, in my opinion, targets most specifically are primarily the people who are victims of these types of crimes are primarily women. And this bill allows most exclusively or most directly women who don't have a lot of means, who are exactly the people who need to terminate their leases because they can't afford to pay maybe for 2 apartments or 2 homes. And so it's my position that this bill helps to protect some of our most marginalized women who may not be able to escape an abusive situation without this type of bill. I will say the bill does provide for, you still do have to pay that 30 days notice. That's part of how the bill is, or 30 days rent. It's not great. There were some people who reached out to me on the Housing Commission after the fact and said, can you remove that too, right? But we're not, that's a concession. But I hope that answers your question, Senator Rouse.
Thank you.
Rouse, if that completes your question, Senator Reeves wanted to follow up on it.
Thank you, Mr. Chairman. So the way I read this is any tenant who's a victim of all those different definitions of code section. But let's say I'm a victim of family abuse as defined by 16(1)(2)28, but I don't have a protective order or temporary or permanent, right? How do I prove it? Do I go to the court and because I was a victim, I'm going to be in the court record? Or how do I take, if I don't have the other two, 1 and 2, and then you get to the court has entered an order of conviction of a perpetrator under the 3rd paragraph, but they don't live in the household. How do I, as a victim, prove that I'm a victim?
Mr. Chairman, Senator Reeves. So I think that goes back to this statute only covers victims of these types of crimes who have gone and applied for and been granted an emergency protective order, a preliminary protective order, a permanent protective order, any 3 of those, or who the police, after they have done a probable cause investigation, right, have gone to the magistrate and gotten a warrant, an indictment, a grand jury has returned an indictment or an information, which is done through a slightly separate process. But those are exactly the protections. It doesn't protect, it's not going to I mean, there are potentially going to be victims who never go to the police, right? Of course, that happens, and this bill doesn't deal with those folks.
Mr. Chairman, follow up.
Yes, Senator.
So I guess I understand what you're saying, Senator, but the way I read the bill is that it doesn't say I have to have 1 and 2, a temporary protective order or a permanent protective order. I don't have to have those 3 before I can do it. I'm just saying if I fall into the paragraph A, and I don't have 1 or 2, and let's say the person who did all these things, how do I go and prove to my rental company that I am that person if I don't have it? Like, I'm a victim, right? Do I get something from the Commonwealth Attorney that says I was a victim in a case?
I'm sorry, Mr. Chairman, and
Wait,
Senator Reeves.
if I could just address that for a moment, and you can correct me if I'm wrong, Senator, but it seems to me if you've entered into the judicial process in any way by either getting a protective order or law enforcement took your sworn testimony seriously enough to charge or convict someone, that then you're eligible to have your lease terminated. Is that correct, Senator?
And I apologize, Mr. Chairman, Senator Reeves. I'm not sure I entirely understand your question. What the bill says is that if you are a victim of one of those classes laid out in Section A, it then says you may terminate your rental obligations under the following circumstances, and then you revert down to 1. 1, it says the victim has obtained an order of protection. So you would literally take your order of protection, a document that you have, whether it's for your emergency protective order, your preliminary protective order, your permanent protective order, and you would go serve it on your landlord, right? The same thing for 2, which deals with charging documents. So you would take a copy of that warrant, you would take a copy of the information, a copy of the indictment, and you would go and serve it on your landlord. That's how you prove it. I mean, proving that you're maybe the person outlined, right, in the protective order, your name is going to be included in that protective order as the respondent in said protective order.
Mr. Chairman.
Senator Reeves, you follow up?
Yeah, it's just, Senator, so I follow what you're saying. So I've got to either do 1, 2, or 3 to qualify.
1, 2, or 3 of?
That code says, I either got to get a temporary or permanent, or I got to go to the court who has issued a conviction on the perpetrator and provide that conviction where hopefully I'm listed as a victim in the case.
Yeah.
Well, on the protective orders, you would be listed as the respondent or as the respondent, right? That's how protective orders work, right? Like the document is a protective order. It says has you would be actually the petitioner. So it would be the petitioner would be you, the victim, right? And the respondent would be the other individual, the person against whom the protective order is issued. So it would be lined out there. In terms of the warrant information or indictment, they often say, did assault and batter X and put a person's name, did rape X, whatever that person's name is. Sometimes they use initials in cases of sexual assault or other specific things, did stalk a person. And I think typically the case law, I know when I was a prosecutor, we usually included the person's name because we're making specific allegations and we have to put the defendant on notice of exactly what we're alleging. And so I think that's how you would go about doing it.
Senator, is it not correct that this is an effort so that you can't just say to your landlord, someone's abusing me, let me out of my lease, that you have to show that there's a serious law enforcement involvement to that level.
Absolutely, Mr. Chairman. This bill is meant to allow victims to terminate their leases early, again, to escape their abuser, but also have some protections in place to make sure that that process, try to make sure that process is not abused. Hey, I just don't like these apartments anymore. I just don't like my rental property anymore. I don't want to live here, so I'm going to go say maybe that, make an allegation that isn't accurate. And again, I think it's further protected by, perjuries or making false statements. So law enforcement, if you were to, make something up that wasn't true to just so you can get out earlier.
Okay, thank you. We've got some other folks who wanted to comment on the bill briefly. Come on forward.
Oh, no, you're fine, you're fine. Good afternoon, Mr. Chairman, members of the committee. My name is Janae Craddock with the Virginia Poverty Law Center. And I am opposed to this bill. I will tell the court that we are advocates for victims. We actually helped to work on the bill last year that passed, which is the current law, but I have some concerns about the bill, this bill as it stands. One primarily being what has already been discussed, which is the inclusion of the emergency protective order. That is an ex parte hearing, and there's been a lot of conversation about what that all means, so I won't go in detail about that. But my concern is that when the person who goes to get an emergency protective order, they're going to a magistrate's office, and there is limited information available. The only information that magistrate will have at their disposal is what that person is saying. And on its face, if that's a victim, that sounds fine, but I believe there are some unintended consequences that we have not considered. In this particular instance, one being if some victim is in a true domestic violence or some other type of situation, there may be a race to the courthouse or a race to the magistrate's office in which the perpetrator can actually re-victimize that victim by obtaining a 72-hour, because that's all it is. EPO is only a 72-hour order, okay? And so with the 72-hour order, that person is still now allowed to terminate their lease, which means that if it's a true victim, that's fine. But otherwise, I think we may have some unintended consequences. And that's something that I think myself and the Virginia Poverty Law Center has a concern with, and we're happy to, to speak with the committee members, committee attorneys, as well as Senator Perry about that. There's some other issues as well, but primarily, I think that is one of the glaring issues that would cause us to express opposition today.
And may I ask, did you express your concerns to the Housing Commission when they vetted the bill?
And I'm not a member of the Housing Commission, so no, I did not.
Okay, thank you. Okay. We have Senator Rouse has a question.
Yeah, in your scenario, can you just help me follow along?
Yes, sir.
So someone who goes and gets a emergency protection order from a magistrate, you said there's limited testimony and the magistrate can grant that, right?
Mr. Chairman, may I speak? Okay, so to clarify that, because
let me elaborate more on my question.
Yes, sir.
I'm just trying to understand. So a victim, you said the perpetrator whoever gets to the courthouse first, right? But the purpose of this bill is so victims can end their lease, not to perpetrate in terms of the legal system. Now, it could be manipulation, but I'm trying to understand how a perpetrator can go down and say, I've been a victim, get an emergency order, then come back and end their lease.
So let me clarify that. So they may terminate the lease, which means that maybe that abuser can now leave the home, the perpetrator, so to speak, and now that leaves your victim in a home where they are now fully responsible for the care and concern of their home, the bills, and all those things. And so we're in a true DV cycle or anything like that. Not only may there be physical violence, but there also may be that financial component there. And so I think this may it could possibly, and not say that, but I think it's something to be explored, whether this is something that gives another tool in that toolbox or toolkit that someone can use against the victim.
Thank you. Okay, before we hear our next one, Senator Reeves wanted to comment. We're gonna try and move this along after this bill.
Yeah, my apologies, Mr. Chairman. I think the young lady that's speaking right now is absolutely correct, because as a former law enforcement officer, I remember they were he said, she said warrants that somebody would run down after a domestic situation and go to the magistrate as quick as they could to get that temporary protective order to get whoever out of the house because they wanted retribution. But I have a question for the patron and the Poverty Law Center as well. Would you be more comfortable with it if we took the temporary protective order out but left in the permanent, because a permanent protective order is a lot harder to get, and usually those come after a conviction in most cases of, malicious wounding or whatever those cases are, because I think the challenge that I think they're bringing up is that 72 hours, you can accomplish a lot to do to somebody else with malicious intent, and that individual, provided they serve can find the individual to serve the protective order on, it's very difficult to undo. I
Mr.
guess
Chairman,
that's my question.
Senator Reeves.
Yes, Senator.
If I can.
Please.
I think, first of all, there are three different types of protective orders. There are emergency protective orders, preliminary protective orders, and permanent protective orders. And as I said, actually, this group sits on the Housing Commission, and the person who sits on the Housing Commission voted this bill out for what that is worth. On top of that, criminal processes can always be abused. Of course they can. That's true with an emergency protective order, a preliminary protective order, a permanent protective order, a warrant, right? Of course they can always be abused. What this process is seeking to do, though, is to provide protection to victims of some of the most serious offenses that we see: sexual assault, domestic assault and battery, stalking, human trafficking, at the point in time which they are most in need, which studies say are in the moments when you are trying to leave, which is exactly the period of time that emergency protective order covers. And so how do we prevent against abuses? That's 72 hours. And I'll tell the senator, Mr. Chairman, that we had a case in Loudoun where the husband was released after he had strangled his wife. He went straight to her house and took a hammer to her head and bludgeoned her. That 72 hours, waiting 72 hours and saying, no, you have to now go get a preliminary protective order, the emergency protective order isn't going to be good enough, would have cost her life. This bill would not have saved her. This is a bill about victims of the most serious and heinous crimes. What is it that prevents people from getting warrants that are not justified? What is it that prevents people from getting protective orders that are not justified? And the answer is we have magistrates. We have judges. Emergency protective orders are issued by magistrates and by judges. Either one can. And as I mentioned earlier, these statements, making false statements, right? Making false allegations, right? We have protections against that. You can then be charged with perjury, right? You go write something out that's not true, you swear under oath, which is what you do whenever you go get a protective order. Right. So there are disincentives to that kind of behavior. And I think the senator referenced, well, a permanent protective order, that's at the end. But there's nothing that is the current law. And at that point, the law becomes essentially useless. Who's in the same lease situation when they have been through a process, a criminal process or a permanent protective order process that could last years? Who's in the same lease? Isn't the point of the bill to help people get out of their leases whenever, at the point in time when they need the ability to get out of their leases to escape their abuser? It defeats the entire purpose to have the bill as it is now. And I would just the permanent protective order is the current law. And so if the abuse is inherent in the system, the abuse is still inherent in the system. I assume it's a bill that you voted in favor of last year.
Mr. Chairman,
Senator Reeves.
I would just comment back that a protective order really is nothing. Quite frankly, as a law enforcement officer, if I'm a perpetrator, I can violate it, like you said, all day long. I think what this is trying to do is give some financial relief to the victim so they don't have to pay their rent. They can leave anytime they want right after that incident and go wherever they want and go live in a hotel if they can afford it, or go see a loved one, stay there, right? They don't have to stay in their apartment or their home. But what this bill is trying to do, I think you're trying to do, is give some financial relief to those individuals that are living in those places to where they don't have to pay the rent because that same person the perpetrator that conducted the violence, which is most of the time a spouse or a boyfriend or whatever that lives in the same residence, that they don't have to continue to pay that rent there. And so I agree with you in the sense that I think we need to do something to help protect them. I just think that the immediacy of getting out of the house has nothing to do really with the protective order. If you're going to keep them safe, they can leave. That the protective order is just a piece of paper that says, hey, you can't come back, or that perpetrator can't come back, or you got to stay away from the victim from wherever they are. And I don't know that, in 72 hours, I can see where some people, if they were wanting to get out of there, at least would use that. But I don't know that they would truly, as a victim, I would like to see them get that relief, to get that financial relief. I don't know. I'm just a little cautious about that first part being so short.
Thank you, Senator Reeves. Okay, were there others who didn't speak yet? Yes, please.
Thank you, Mr. Chairman. Erin Corman with the Realtors. We support the intent of this bill, and we have spoken with the senator several times. Our only concern with this bill is the emergency protective order, the 3-day order. We do not want to take out the preliminary protective order. Our only concern is with the emergency protective order. We did bring that concern up at the housing court. We weren't able to come to a consensus, but we very much support the intent of this bill and would love to find a way to come together and get it passed.
Okay. Okay, so we're going to take a vote in a moment if there's a motion. But Senator Perry, I have the impression that you prefer the bill the way it is and want it to pass with that in it, and that you don't want to change it. Is that correct?
That's correct, Mr. Chairman.
Okay. So is there further discussion or a motion? Is Senator Rum?
I have a motion. I'd like to speak to the motion.
Please.
All right. Thank you, Mr. Chair. Motion is going to be to report the bill. The request would be if the senator from Orange and the senator from Loudoun can basically kind of take things up and try to work out something between now and when it goes to floor, or if there's anything further. At the same time, if we're going to err in any direction, it should absolutely be in the sake of the person who was described by the senator in terms of having someone with a hammer chased after them. I would much rather default to that person than default to a horrific situation that could otherwise be preventable.
Thank you. And we have a motion and a second. I think, though, that Senator Perry feels strongly to keep it the way it is and doesn't want to work to modify it at this point. So I think we should just vote it up or down. Is your preference? Is that, am I, okay.
Correct, Mr. Chairman.
So we have a motion and a second. And I guess unless there's further discussion, we'll have a vote. Please indicate your preference. Senator Rum, you have a proxy for Senator Carol Foy? Okay. So the bill
Chairman.
Ayes 12, no 0, 2 abstentions.
Okay. So that bill is reported. Then there's, you have another bill, Senate Bill 885.
Yes, Your Honor. This is a bill that, Your Honor. Yes, Mr. Chairman.
I'm honored.
Yes. This is Bill, Senate Bill 885. This comes out of the Behavioral Health Commission. It also reported out, I think without objection. It has a House bill component as well, and it just adds to the list of entities that the Office of the Inspector General must keep informed about issues in state psychiatric facilities. It adds the Behavioral Health Commission to that group of folks who get notice.
Okay, so we have a bill that was reported from commission that is very simple. Is there anyone against it in this room? Anyone online against it or for it? Okay, there's a motion and a second to report. Unless there's discussion, we'll vote on the electronic voting board.
Ayes 15, no 0.
Thank you, Mr. Chairman.
Thank you. Okay, next we have Senator Favola, who's been patiently waiting.
Thank you, Mr. Chairman. I've got 3 bills before the committee. I'll just take them in consecutive order. The first bill is Senate Bill 748, and there is an amendment in the nature of a substitute. I hope it's the will of the committee.
Okay, is staff have an amendment to pass out?
Move the substitute.
Okay, there's a motion and a second to adopt a committee substitute. All in favor, please signify by saying aye. Any opposed? Okay.
Okay.
Senator Favola, please tell us what
Thank
this
you,
substitute does.
Mr. Chairman. What this bill does is it sort of tightens up, the amendment tightens up the intent of my originally submitted bill. It takes out references to a stakeholder group, but it directs the Board of Housing and Community Development during the 2024 Virginia Code development cycle to evaluate potential revisions to the building code. This came to me from constituents and a number of advocates who are living in apartments or multifamily housing and believe that the air conditioning is not put on soon enough, or heat is not put on soon enough, and they would like that condition evaluated. So my bill actually provides a time period where we believe air conditioning or heat should be turned on, but we are, of course, waiting. This bill would wait for the Building Commission to actually do its review. So it's very straightforward.
Basically, we're asking a commission to evaluate this issue, and you want the Board of Housing and Community Development to do it rather than like the Housing Commission. That's the appropriate place that you want this considered?
Yes, the administration came to me and said that this would probably be the proper format. So it is the Board of the Housing and Community Development. I did work with the home builders. Andrew Clark was also in the stakeholder meeting.
Thank you. Is there anyone in the room in opposition to this simple bill?
Those online who wish to speak to the bill, please raise your hand.
Anyone who wants to express support online or in person? Or any online hands raised? Okay. So is there a discussion or a motion?
Move to report.
Okay. Moved and second to report Senate Bill 748 as the substitute. We can indicate our preference on the voting board.
Ayes 9, no 6.
Okay. The bill reports. And then you had another bill, Senator.
Yeah, I have 2 others, so I'm going to sort of sandwich the maybe a little bit more controversial one in between. I draw your attention to Senate Bill 754. What this bill is intended to do is protect menstrual health data when it is stored on an app. The bill puts the language in the Consumer Protection Act and discusses the willful release of such information. So there's a high bar, but it does provide for a private right of action. And the intent, like I said, is to ensure that obtaining or disclosing or selling or disseminating any personally identifiable reproductive or sexual health information without the consent of the consumer would be a violation of the Consumer Protection Act. This bill is very similar to a bill that Delegate Marcus Simon introduced last year, and the Senate did act on it. A bill very similar to this, like 95% similar, if not 100%, landed on the governor's desk last year, but it was vetoed. I put this language in the Consumer Protection Act rather than in our data protection section of the code, because frankly, in the backdrop we have today of reproductive health becoming such a political football, I felt it was important that we provide for a consumer right of action. If I just put it under the data protection section of the code, there is no personal right of action. It would be up to the AG to enforce it. And individuals felt that that was just too political a bar at this point in time.
Thank
So
you.
that's the full
Thank you for bringing
background.
this forward. Are there questions for Senator Favola? Okay, I think people are familiar with the topic. Are there those in the room who oppose this legislation who'd like to come forward?
Those online who oppose the bill, please raise your hand.
Thank you, Mr. Chairman, members of the committee. My name is Jessie Blakely, here on behalf of the Family Foundation. I'm here today to express our concern with SB 754. While we support the principle of an individual's right to privacy regarding their medical records, we are concerned that this bill, like last year's bill, as it's written right now, we think it unnecessarily ties the hands of law enforcement engaged in combating harmful and predatory behaviors. This bill could prevent collection of information of an evidentiary nature on people engaged in unlawful sending of abortion drugs or hormones. We have seen cases in which individuals engaged in unlawful sending of abortion drugs causing harm to women who are seeking care. Additionally, there are documented cases of individuals such as Eli Ehrlich, who is an activist from New York, who are not medical professionals but engaged in organizing online to send hormone treatments to minors. If this bill were to pass, a prosecutor, law enforcement officer, or an attorney in a civil suit could not issue a subpoena for such records to be able to prosecute or civilly sue someone who is engaged in this type of illegal and dangerous activity. This law makes sure that there is no trace of those criminal activities from online traffic. Someone who's not qualified as a medical professional can use online means to cause serious harm. So we believe that this bill, as it's written, would make it harder for law enforcement to find those people and hold them accountable. And for those reasons, we ask you to oppose this legislation. Thank you.
Thank you. Any others?
Mr. Chairman and members of the committee, I'm Olivia Turner, President of the Virginia Society for Human Life. We also definitely understand the intention of the Senator's bill and do not oppose the concept of this. We have no intention, I know the larger pro-life movement has made it clear in repeated statements that have been signed by over 75 organizations that under no circumstances is there an intent or an interest in pursuing or persecuting any individual for having obtained reproductive health or abortion services in that way. That is not an issue for us. We commend you for that concern, Senator. What we are concerned about is that unfortunately right now, because of Virginia's status, we know that there are a number of pop-up organizations, mostly along the borders of the Commonwealth, approximately 12 of them, that are helping to disseminate information about how to acquire chemical abortion drugs and sending them into other states. There may be a way to pursue your goal in a way that would actually make sure that we're not violating the well-being of the women that might be receiving drugs from our state without any protective measures. So we would hope that perhaps we could look again at this issue in a way that recognizes the weird state of affairs that's going on right now in Virginia, which could in fact endanger the lives and well-being of women in other states who are obtaining chemicals from our Commonwealth. So thank you for listening.
Thank you. Okay, and then in the room, are there those who feel that they would like to express support briefly? Okay, please come forward.
Hello, Chair, members of the committee. My name is Latwyla Mathias. We're the Executive Director of Progress Virginia, and we fully support this legislation. Reproductive health data is the most personal data that a person can have, and we believe that that data should be protected, and we thank the patron for bringing the bill. Thank you.
Thank you. Okay, we have online someone who wanted to speak. First, we'll take anyone who's opposed. You have got 1 minute each.
Margaret Durkin, please turn on your camera and unmute your microphone.
I have to ask a question first, just to give notice. We said we weren't taking online testimony from registered lobbyists. Are you a registered Virginia lobbyist?
I am registered in...
Because this is the first meeting, I'm just going to let you speak really briefly, but in the future, we're not going to take online testimony from registered lobbyists.
Okay, thank you, Chair Eben. My name is Margaret Durkin. I'm with TechNet. I am based in Pennsylvania. I do come to Richmond here and there. However, I am a few hours away, so I can't be on the ground full-time. Conceptually, related to Senate Bill 754, we agree that the protection of consumer health data is of utmost importance. However, we disagree with the bill's approach. I submitted written remarks to the committee as well as the sponsor regarding some of TechNet's suggested changes, mainly to amend the Consumer Data Protection Act and classify reproductive or sexual health data into types of sensitive data, as well as offer a couple of new definitions to really target this bill and avoid unintended consequences. So we would appreciate your consideration of our request. Thank you.
Thank you, Ms. Durkin. Okay, were there others? Okay, so I think the committee is clear on the goal of the bill and the similarity to previous legislation that we've considered in the Senate and this General Assembly. So unless there's discussion or questions, I would entertain a motion.
Move to report.
Okay, it's been moved and seconded to report and we refer to finance. So let's express our preference on the voting board.
Ayes 9, no 6.
Okay, so the bill reports and referred to finance. Okay, and that was, you have one more, Senator?
One more. Thank you, Mr. Chairman. It's Senate Bill 842, and I do have some line amendments to Senate Bill 842, so I would ask that the committee adopt those line amendments.
Okay, does the clerk want to, are they in writing or did you want to read them?
They are in writing, but they're very simple. I can read them if that assists.
Well, why don't you read them while they're being distributed? Or, yeah, thank you, or I have a copy, okay.
I can tell you, one is just sort of a nomenclature change. We had used the phrase deployment programs with respect to the federal broadband equity access program, and we were supposed to use non-deployment. So we made that technical change. And then on line 15, we actually had to insert to the extent approved by the National Telecommunications and Information Administration, because we are using federal money, and how we use that money in some cases has to be approved.
Okay, so I will entertain a motion to adopt the line amendments and seconded.
Mr.
Is there
Chairman,
more than these three, or?
One other thing, we did remove the reporting requirement because projects that are funded with our broadband money they go up on a website, and also the gaps are identified. So there didn't seem to be the need for a report. This is a recommendation from the Joint Commission on Health Care.
Okay, so you'd like to strike the part that says the department shall provide a report to the Joint Commission on Health Care on current gaps?
Yeah.
Okay, so that's among these amendments. It's not in writing on this sheet, but that's included in that motion.
It is.
Okay, all in favor of adopting the line amendments, please say aye. Aye. Any opposed? Okay, so we have a simple bill to improve broadband for mobile health clinics. There's a motion to report. Is there anyone in the audience who's compelled to speak against or for?
Those online who wish to speak, please raise your hand.
Was this?
Yeah.
Okay,
Refer to finance.
so we have a motion to report and refer to finance. Please express your preference on the voting board.
I just want to note that the Joint Commission on Health Care, through their analysis of mobile health clinics and their value, we have seen a reduction in the cost of health care and more opportunities to access health care. So
Thank you.
I appreciate the strong support from the committee. Thank you, Mr. Chairman. Thank you, committee members.
Okay, thank you, Senator Favola. Next on my list, Senator McDougall, are you, is he here? Okay, he had a time commitment. I don't know if he's back from court or whatever, but I don't see him in the room, so we're going to go to Senator Suderline.
Thank you, Mr. Chairman. I've got Senate Bill 785 for your consideration, and there is a substitute that I believe council has.
While the council is distributing it, is there a motion to adopt the committee substitute and a second? Okay, all in favor, please say aye. Aye. Any opposed? Okay, the substitute is before us and being distributed. Senator Suderline, why don't you describe it?
Thank you, Mr. Chairman. I'd ask the committee to go to lines 56 through 59, which is the entire bill right there at the end. And what it seeks to do is make it clear that when a real estate license is transferred between offices in a real estate firm from often the main office or branch office to another one, that there won't be a fee incurred. And this will be less significant going forward. This summer, DPOR is going to be making changes to have an electronic system to do this, which will work much better. This came at the request of the Virginia Realtors. This is something that comes up especially in a lot of our larger offices. You might have 5 offices in Fairfax County. The company I work at in Roanoke, we've got 6 offices just in the Roanoke Valley. And it's not uncommon for people to move from one to another. And I think the council from the Virginia Realtors would like to speak if...
Council from the Virginia Realtors or you. When it says licensee for the transfer of such license between offices or licensee within a licensed real estate firm, is the licensee a realtor, a person, a human being who works for a real estate firm?
Yeah, the licensee would be any real estate licensee, so a real estate salesperson.
Okay, so basically if I move from a branch of a real estate firm in Manassas to one in Haymarket that I don't have to pay a fee, once I'm a licensee?
So the way the organizational sort of structure works is you have a primary place of business, but you can have multiple offices underneath that are called branch offices. So if a licensee was transferring from a primary place of business to another primary place of business, there's still a fee. The duplicative fee was coming in place when you brought them into your primary place of business and then wanted to put them in a branch. You have to basically click the button twice, and they were being charged the full fee twice.
Okay.
So it's just the duplicative part that we're trying to prohibit.
Thank you, and this was a recommendation of your organization?
Yes.
Okay, and what is, just out of curiosity, what kind of fee were they charged for that? Is this like $50 or $100?
No, it's several $100s.
Okay.
But actually, I think it's about $95. But when you're bringing in, the example that we have is they were bringing in a team, so it was like 4 agents. They brought them into the primary place of business and then put them in a branch. So they ended up paying $400 twice.
Okay. So before we proceed with other testimony, the motion would be to report and refer to finance. Are there questions for the realtors or for the sponsor? Okay, it's pretty straightforward. Is there anyone in the room who's against the bill?
Those online who would like to speak to the bill, please raise your hand.
It's always exciting.
Okay. I think we're pretty clear. Is there a motion?
Mr. Chair?
Yeah.
As the senator representing Manassas and Haymarket, I move to report and re-refer to finance.
Okay. Okay, there's a motion and a second. All in favor, please, or indicate your preference either way on the voting board.
Ayes 15, no 0.
Thank you, Senator. Did you have another bill, or is that it?
That's
for today?
it. Thank you,
Okay.
Mr. Chairman, and thank you, committee.
Okay, next we have Senator Sturtevant.
Thank you, Mr. Chairman. Members of the committee, I've got Senate Bill 766 before you. This is a bill to lay the groundwork for the creation of the Museum of the Virginia National Guard. We are the only state of the original 13 colonies without an official National Guard museum, despite the fact that Virginia has the oldest branch of the National Guard dating back to the original Jamestown Settlement Militia in 1607. And it's actually been almost 40 years since the Adjutant General of Virginia signed a permanent order to establish the museum in 1986. And so that is the bill, is to create the museum as a state agency Mr. Chairman. And there is an associated budget amendment for initial engineering planning to get this up off the ground. As I understand it, the National Guard Foundation voted to house this, to create this museum in western Henrico near the Libya Mill area. And so that's the bill. I have someone from the National Guard Foundation to speak to it, as well as Alexis Bowles-Fryer from the Department of Military Affairs.
Before we hear from them, just out of curiosity, how big or how costly an endeavor is this? You said you had a budget amendment.
The first year, it's $300,000.
Okay, thank you. Please come forward.
Good afternoon, Mr. Chair, members of the committee. My name is Alexis Bowles-Fryer. I'm the Policy and Legislative Analyst for the Department of Military Affairs. The agency itself holds no position, but we do agree with Senator Sturdivant. We are trying to create this educational, recreational, and training facility for Virginia Guardsmen, not only Virginians themselves within the Commonwealth, but also Virginia Guardsmen to boost their morale and to give them a physical entity that allows them to show off their accomplishments within the Virginia Guard. And I can answer any technical questions any of the members might have.
Do they have a training facility now, not in
Excuse
Virginia?
me?
Do we have a training facility already, or?
Yes, we do
But
have
this
a
is
training.
another space?
Yes.
Okay.
Yes. So it'll be a multi-use facility, meetings, trainings. It will house all of the artifacts, things like that.
Great. Okay, Senator Pillion's got a question.
So where will this be, Mr. Chair? So where will this be located? I'm assuming Sandston?
No, so this is actually going to be located at 5001 Waller Road. It's right off of Staples Mill Road at we currently own that location. It's the S. Gardner Waller Depot.
Okay.
And we have, was
Mr.
that
Chair.
complete your remarks?
Yes.
Okay, and you had wanted to express support, or?
Thank you, Mr. Chairman. I'm Bud Oakey. I'm a member of the Virginia National Guard Historical Foundation Board, serving under TAG 28. Major General Tim Williams is our chair. It's an all-volunteer organization. We're tasked with raising a major portion of the money for this facility, but we do need this initial money here so we can do the engineering and design for this facility at Waller Depot. And we ask for your support.
Thank you.
Yes, sir.
Is there anyone else online or in the audience who wants to express a preference on this bill? Okay. Is there any discussion or a motion?
Move to report to finance.
Okay. There's a motion and a second to report and refer to finance. All in favor, indicate your preference on the voting board.
Ayes 15, no 0.
Okay.
Thank you,
Okay.
Mr. Chairman.
Thank you, Senator. We have Senator McDougal next.
Thank you, Mr. Chairman. Mr. Chairman, did y'all refer 1164?
We referred your other
Thank
bill to
you.
finance.
Thank
I
you,
don't
Mr.
have the
Chairman.
number. Yeah.
Mr. Chairman, I have 787.
Okay, so we'll direct our attention to Senate Bill 787, dealing with the Department of Housing and Community Development report consolidation.
Mr. Chairman, even though this bill looks lengthy, it is pretty simple. Right now, the Department of DHCD has over 25 annual reports that they are tasked with producing. The dates of those annual reports are all different, and this would consolidate those 25 into one report, require all the same information to be reported, and it be on one date, October 1st, which the agency says they spend just a tremendous number of man-hours doing the different reports. One report will save them a tremendous amount of time and money. But you get all the same information.
Thank
We
you.
would get it before a lot of them come now, which means we could do something with it if we wanted to.
Thank you for that clear, concise explanation. Is there anyone who would be against consolidating these reports who wants to come forward? Okay. Anyone who's for it, who wants to come forward, feels that.
Chairman, I think Mr. Horn is in the audience somewhere. But Judge, Mr. Chairman, sorry, we were just in federal court.
Okay.
It's a habit. I was hoping
Call
somebody
me
was
Your
going to.
Honor. Other witnesses have it today.
I was hoping somebody was going to oppose it. I could ask them how many of the 25 they've read each year, but.
Okay. Is there anyone online with their hand raised on this one? Okay. So we'll vote on the voting board to, was this a report? No. Just straight out report? Okay. All in favor indicate by voting green.
Ayes 15, no zero.
Okay. Thank you, Senator.
Thank you, Mr. Chairman. Thank you, members of the committee.
Okay. Next, we've got, I don't know if Senator Williams-Graves is back, and then we've got Senator Stanley. So we're going to get non-members first. Senator Stanley?
Thank you, Mr. Chairman. Good afternoon. Senate Bill 913 before the committee.
Okay, so we'll move to Senate Bill 913.
I believe there's a amendment in the nature of a substitute. Can I get an extra copy?
Okay, is there a motion to adopt the amendment in the nature of a substitute? Okay, been moved and seconded. All in favor, please signify by saying aye. Any opposed? Okay, well, that's before us.
Yes, Mr. Chairman, members of the committee, thank you. Senate Bill 913 is a bill actually in a different form that we had last year before this committee. If you recall, my bill last year would have made that if the government were to procure electric vehicles, they would do so with the assurances that the cobalt that was used to generate or to create the battery were not sourced from countries or industries that used slave labor, forced labor, or child labor. A lot of that cobalt comes from places like the Congo, where they do employ that kind of labor. We had last year a gentleman who had escaped Congo, had been in these labor camps mining the cobalt. And so what you had made of the recommendation of your Senator von Valkenburg was to refer this to the procurement work group that we have, where a lot of our agencies come together and discuss issues of procurement. And I made a presentation to them, and they supported it, and then it was sent to the Manufacturing Commission, chaired by Senator Williams-Graves, who, after discussion with the Manufacturing Commission, unanimously agreed that we should put this forward, not just as a policy decision, but also that we need to make a statement in Virginia that we're not going to buy things that come from these sources. The amendment in the nature of the substitute actually simplifies the bill. It was offered by Charles Qualiato of DGS, formerly of Senate Courts and LIS. But basically that is that now what we do is that when we enter into contracts that exceed $10,000 with a firm, that they must, as a part of the contract, as they do when they say that it is a drug-free workplace, that they are certifying that they are prohibiting the use of forced labor, oppressive child labor, slave labor in the performance of the contract, and or the acquisition and sourcing of the goods to be bought using taxpayer dollars in the Commonwealth of Virginia for the benefit of the Commonwealth of Virginia's government. And so that's basically the bill now. It is the same as we do, Mr. Chairman, for matters when we contract with third-party vendors where we certify that it is a drug-free environment within that workforce. I know Mr. Qualiato is here from DGS who could explain anything more that I might not be able to.
Okay, can you explain any differences in the substitute from the original bill? Is there any significant changes, or what is the change?
Mr. Chairman, there is a significant change, and that is that there had to be a certification previous to that, and it was not maintained inside the contract. So there had to be a third-party certification provided to the Commonwealth that in awarding of contracts, they had not used sourcing from that list of products produced of forced labor, indentured child labor maintained by the United States Department of Labor of International Labor Affairs without a third-party certification. So what we do is then we just have moved that down into the contract, which they make that certification there.
So they affirm it in the contract,
Yes,
up to us, okay.
Mr. Chairman, so in the contract between the government and the third party, in that contract would be an acknowledgement that they're not acquiring or sourcing their products from oppressive slave labor, child labor,
Okay.
or other things that are banned from, again, that list of those issues that are listed by the United States Department of Labor Bureau of International Labor Affairs.
Okay, that's fine. Welcome, and did you want to speak briefly?
Good afternoon, Mr. Chair. DGS supports this bill. It more aligns with what the Public Procurement Work Group did over the summer.
Okay, thank you. Are there any questions for Senator Stanley? Senator Rum.
Yeah, Ms. Chair, question for the patron. Could the patron also, and perhaps for our witness here as well, just talk about the EV fleets that are purchased right now by the Commonwealth, and basically, based on what the patron was saying, I don't think that we're going to have any future issues with it under this bill, but just what are going to be more or less any parameters around dealing with batteries or anything, especially since we have battery production coming online here?
Mr. Chairman, I'd answer the gentlelady by saying Charles probably from DGS would know that better than I. Charles, would you hazard a guess or an answer?
Mr. Chair, I don't believe it would affect current operations. It would just be, if this was to become a law, it would become part of the standard terms and conditions of the contract.
Thank you. Okay. Were there any other questions? Okay. Anyone who's compelled to speak against this legislation in the audience?
Those online who wish to speak to the bill, please raise your hand.
Anyone who is compelled to speak for this in the audience? Or online, were there any hands raised? Okay, so is there any discussion or a motion? Is this go to finance or is this just go report? Okay, this can be, the motion would be to report,
Mr. Chairman.
or otherwise. Okay, there's a motion to report and the second, so indicate your preference on the voting board.
Ayes 15, no 0.
Okay, thank you, Senator. Was that that was your only bill today, right?
Yes, Mr. Chairman, I appreciate the time of the committee.
Okay.
Mr. Chairman, he is correct. That's the only bill I've gotten passed so far. I'm having what I like to call an Amanda Chase summer. It's
early in the session. You might have luck, but with comments like that, we can always recall this.
I'm out of here. I'm gone. Thank you.
Okay. I'm going to ask Senator Williams-Graves to lead off among committee members who want to present. I believe.
Everybody said they got.
One sec. One sec. What was your bill number?
Bill number 993.
Okay, so Senate Bill 993 on the D4 bill. Okay.
Senate Bill 993 is clarifying language to update exemptions under the Virginia Code for real estate brokers, salespersons, and rental locations. It ensures compliance with the real estate regulations while specifying conditions for exemption. I can tell you as much or as little as you as little as you want. Okay, so in a nutshell, the bill is designed to clarify that rental agents, that leases and those documents of the sort have to be negotiated by a licensed realtor. Anyone who is basically an office manager or working in an office can have those documents signed, but they cannot negotiate the lease, or they cannot negotiate the deposit. They cannot do any of those things. So this is clarifying language for actually legislation that was passed in 1998.
Okay, so let's property managers and others sign a rental contract or a real estate.
It lets the already negotiated lease be presented to a tenant and signed off on by an office manager. But that office manager has no authority to negotiate or renegotiate that lease. They never have. And so this just clarifies that.
Thank you. Is there anyone, and there's an emergency clause on the bill. So
there is an emergency clause, yes.
Okay. Is there anyone who's compelled to speak in favor of this bill in the audience?
Those online who wish
Please
to
come
speak
forward.
to the
Hi.
bill, please raise your hand.
He said be short, don't kill my bill.
I won't kill your bill.
Thank you.
My name's Chip Dixon. I agree with everything she said.
Thank you.
How about that? I just simply say that there's a question that has arisen about whether non-licensed persons, property managers, can sign the leases or not. And all this does is this is the best practice that a number of companies use. I'm representing SL Nussbaum today from Norfolk, which is how Senator Williams-Graves has this bill. Very important bill to make sure that property managers can sign leases. It's been the best practice for a quarter of a century. And so it's just clarification, that's all.
Okay. And others, if you want to express support, please do so.
Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We strongly support this bill, essentially clarifying existing best practices. So we urge your support. Thank you.
Erin Corman with the Realtors. We support the bill as well.
Okay, is there any one online who's compelled on this to speak on this? Okay, then is there any discussion or a motion? Is this one? This is no financial impact, right? Is the motion to? No. Okay, so the motion is to report, and it's got a second. Okay, so indicate your preference, please, on the voting board.
Present, Mr. Chairman.
Okay, it's working.
Ayes
Okay.
15, no zero.
Okay, and was that your only bill today?
That is my only bill today.
Okay, everyone says they have easy bills, so we'll start on the end with Senator Rum and work our way. Oh, you can stay there. Okay.
Thank you, Mr. Chair. First bill we'll do is SB 1055. And so, Mr. Chair, SB 1055 builds on my bill, SB 281 that we passed last year. That bill allowed for the ability for a family member or descendant of a deceased person to petition the circuit court where a cemetery is located for interment rights. This bill allows the same ability to petition for interment rights, but with public properties if the person can demonstrate family relation to a deceased person buried in a cemetery owned by a county, city, town, or other locality, or held in the trust of a locality for cemetery use. This is a constituent service request that comes from the community thoroughfare. Long story short, we had this horrible situation out there, and at this point, I still have constituents who want to be able to be buried next to their families. And on one of this case,
This will allow the circuit court to make that decision as a safeguard unless there's some reason not to. Okay, is there anyone who's compelled to speak in either side of this bill in the room?
Those online who wish to speak, please raise your hand.
Okay, and is there someone online with a burning desire to speak? Okay, so there's a motion to report and a second. Please indicate your preference on the voting board. Oh, wait, let's strike that board. We have someone online who wants to speak to the bill.
Frank Washington, please turn on your camera and unmute your mic.
Mr. Washington, you've got up to 1 minute, but if you're briefer, it might not slow down the train.
Oh, I'm sorry, my video is not working.
Okay. Well, we require folks to be on camera. Oh, it's working? Okay, great. Well, let's hear your remarks.
Thank you for your time, sir. My name is Frank Washington from Thoroughfare in Prince William County. The county purchased land around two of our family cemeteries, the Fletcher Allen and the Cartersfield, stating that it would help protect them and preserve our rights and their historical significance. My family has been laid to rest beside each other since the 1800s on these. Instead, they purchased properties and then stripped us of our burial rights, leaving my family and my no place to bury our family and loved ones. These cemeteries are registered and have been well maintained by my family. Last year, my cousin died suddenly of a heart attack. The county threatened us with a lawsuit if we buried my cousin beside his mother in our Fletcher Allen Cemetery, a lawsuit for burying his son with his mother, as we have done for nearly 20 years. Rather than having the time to grieve our sudden loss, we spent all week fighting with the county over the rights to let rest. We sought media attention and all avenues to address this. Finally, the night before this burial, I received a call stating there will be no repercussions if we move forward with this burial only. Following this incident, the county then informed my 81-year-old mother that she would not be allowed to lay her ailing brother to rest beside her brother in our family cemetery. This after they assured her they would not take away her right, and she cried and they comforted her in a meeting we had regarding those very rights. Now she carries the burden and pain of what will happen to her brother, where he will rest. A burden and pain that we carry as family.
Thank you for sharing your story. I think the committee is sympathetic to your predicament, and Senator Rome's bill would assist. We have a motion and a second to report the bill. Let's indicate our preferences on the voting board.
Ayes 15, no 0.
Okay, the bill reports. And then you had another bill, Senator Rome?
Yes, Mr. Chairman. The next bill I bring to you is SB 1118. This will amend the code of Virginia related to the registration of cemeteries on private properties by localities. In the 2022 session, the House introduced and we passed HB 968, which allow localities to create a register of cemeteries and require public sales of land containing a cemetery be specified in a public notice in a newspaper with general circulation in the locality. This would change the language from any locality may to all locality shall. And the reason we're doing this is the same person who we just heard from who testified on this, the action that he sought in these last 3 years has not been pursued. And so this is kind of the way of saying, hey, we gave them the opportunity, didn't happen, so now we're going to put some teeth into it.
Okay, so basically there would be a register of cemeteries and graveyards that are not part of what's commercial operating cemetery? Okay. Are there questions for Senator Rome? Yes, Senator Williams-Graves.
What is the cost for this for localities?
Mr. Chairman, that's an undeterminate cost. I would tell the patron, or I'm sorry, I would tell the senator on that. They already have the ability to actually have all of this in the first place. And so having spoken with one of our local government reps earlier, I don't expect that we have anything that's going to be like too much anywhere. The issue that we're having largely is that you have all this data. They already know cemeteries exist, but they're not putting into one registration. And because that happens, we just had an incident where the gentleman who just spoke, he talked about how in his community, he ended up finding a public notice sign on an area where they used to have a church. It was called the Sanctuary Church. And when he called his local county supervisor about it, and he says, hey, I know for a fact there's a cemetery on this, but it's being put up for auction right now. It was not correctly notified or anything like this, blah, blah, blah. And the county supervisor looked it up, immediately found that there was a cemetery located on it within the files. And so the only issue on that case was there was no registration that they should have had to identify that in the first place.
Thank you, Mr.
Senator Rome. So Senator Rome, it's just basically a page on a website or a list or something that would be available to those who request it. Okay. Yes, Senator.
Mr. Chair, Senator Rome. So is this going to require counties to go out and survey old cemeteries off of private-owned land? Because I'm afraid that this is going to cost a lot of our rural county. We have a lot of agriculture land that have cemeteries on that, are there, but the county doesn't recognize them per se.
Mr. Chair, I would tell the senator in that case that generally speaking, that data is supposed to already be available, that they already have that cemeteries are located in the places of burial are already located. That's supposed to be there. It is just a matter of compiling that data. I'll be happy to also defer to our VML and VACO folks who I see lined up as well.
Okay. With those in the audience who wanted to comment further.
Those online who wish to speak, please raise your hand.
Please come forward.
Mr. Chairman, Joe Lurch with VACO. I want to thank the patron for talking with me earlier today. Obviously, when something becomes permissive to a shall and have to adopt an ordinance, we have concerns about what those impacts might be. and particularly when you're talking about private property and trying to get those surveys. But what we said is we're going to reach out to our members to get some feedback on this, on what these impacts could be, and continue to talk to the patron about the bill. So thank you.
Okay. Thank you.
Good afternoon, Michelle Gaudios, the Virginia Municipal League. I would just echo Joe's comments. We've agreed to work with the senator. Thank you.
Thank you. Okay. Okay, there's no one online to comment. Senator Williams-Graves?
Question for the patron. And I have a strong history of not liking shalls and preferring mays, and I understand where the senator's coming from. Is it possible to have a delayed enactment on this so that localities can have the opportunity to assess what, especially in like some of the rural areas, but to assess what is required of them and perhaps get that into their budgets if there's any, I know they're supposed to have it, but if they don't have it, it's going to cost something, and it's going to require some manpower for the locality. So is there the opportunity for a delayed enactment in order to take care of that?
Yeah, Mr. Chair, I would tell the senator, I actually discussed this, I think with Mr. Lurch earlier. I'm amenable to that. At the same time, like, you know, if we want to do like a 1 year, so it would be July 1, 26. Same time, if my constituent, Mr. Washington, is still online to speak to that, I would certainly, you know, ask him to weigh in.
We'll hear from folks online briefly. But so you're amenable to an amendment, depending on what your
an enactment clause amendment, Mr. Chair.
Okay. So we're before we vote on the enactment clause, is there still online anyone who'd like to comment on this bill? Okay, please turn on your camera, and you have a minute.
Mr. Washington, please turn on your camera and unmute your microphone.
Yes. The only thing I'd like to say regarding this is that we have already had over 400 cemeteries in this area already surveyed. The only issue with our situation is that they have not been put in the proper database so they can be recognized by other entities. But that work has already been done for this particular area.
And Mr. Washington, can I just ask, are you okay? There's a proposal to delay this bill 1 year just to give localities time to make sure they can comply properly without a lot of unforeseen circumstance?
Yes, sir. I'll follow Senator Rome's advice, leadership as well in this. I agree.
Thank you. Okay, so I'm going to take Senator Williams-Graves' comments as a motion to add a delayed enactment clause till July 1st, 2026, which a delayed enactment clause. Oh, I'm sorry, I meant to say enactment clause. Till July 1st, 2026. All in favor of that will say aye. Aye. Any opposed? Okay, that's now part of the bill. The bill is before us.
Move to report as amended.
With a motion and a second to report as amended, please express your preference on the voting board.
Ayes 8, noes 4. Two abstentions, I'm sorry.
And just to comment to the clerk, if you can just make sure that Senator Rome's first bill was listed properly. I'm not sure it was expressed on the screen properly with the number, but okay, we'll fix it. Okay.
Mr. Chair, the senator from Henrico's vote did not tally. Could we get that?
Can we add Senator Van Valkenburg as a? Okay. Okay, that bill reports as amended. We have other members. I think Senator Aird, or who had a? Okay, we'll go to Senator Aird, and then we'll work back down to Van Valkenburg and Rouse.
No, I got one.
We'll get down to you. We'll get you next. Okay. I was favoring my right, but I'll work on the left too.
Ready?
Yeah, go ahead.
Okay, thank you so much. Mr. Chair, before you should be Senate Bill 1228, and I do have a line amendment that I'll ask be reported.
Second.
Are we going to distribute, or do you want to read the line amendment or pass it out? Okay,
I can report it if you don't have it.
why don't you tell us what it is, and then we'll vote
Yeah,
on it.
it's really a technical, program naming here in the on line 98. After employed, we are striking pursuit to a work training certificate and inserting a work training program to make sure we're making proper reference to the actual entity. Mr. Chairman.
Thank you.
Move the report.
Okay, before we,
I'll take
before
either
we-
one.
Before we report the bill, we're going to vote on the amendment. And council has the amendment, right? You're clear on what that was?
Yes, I have the amendment here.
Okay, it was as stated. So all in favor, please signify by saying aye.
Aye.
Any opposed? Okay, the amended bill is before us. Do you want to briefly describe that?
Yes, briefly, Mr. Chairman. And basically, in this legislation, we are just trying to make sure young barbers are able to be, 16-year-olds specifically, who are registered apprentices that work with the Workforce Development and Advancement Program. Somewhere along the way, there was some confusion as to what did and did not constitute an apprenticeship. And that resulted in a prohibition on sort of public school students from being able to work in the barber and salon environment. So we are trying to eliminate that confusion by simply clarifying that public school student learners aged 16 years or older working in the Virginia Department of Education barbering or cosmetology program, or 16 to 18-year-olds licensed by the Board of Barbers and Cosmetology can in fact serve in a barbershop or cosmetology salon. And that pretty much is what we're doing.
Move the report.
Thank you, Senator. There's a motion to report. Is there anyone in the audience who's compelled to speak for or against this legislation? Briefly.
Those online who wish to speak, please raise your hand.
Anyone online who wants to express a view? Okay.
Second the motion.
Okay, there's a motion to report. Thank you for that, and we'll express our preference on the voting board. Okay, and was that your only bill? Okay. Okay, before I move to my left, on my right, Senator Van Valkenburg.
Thank you, Mr. Chair.
Ayes 13, no zero.
He gave you a thumbs up.
Okay.
If you can mark the two as yeses.
Mr. Chairman, okay, thank you.
Yes, Senator Van Valkenburg.
Thank you, Mr. Chair. Mr. Chair, members of the committee, I have Senate Bill 1014. And the long and short of it is it's codifying the governor's executive order, which has already kind of been standard practice in Virginia around not requiring degrees for state employment unless absolutely necessary. And so states as diverse as Pennsylvania to Utah have done this. A lot of corporations are doing this as kind of widespread as IBM to GM to Bank of America. I think it's a good policy. We should be wanting people of all pathways to be able to work for the Commonwealth. And I can keep talking or I can stop there.
Is this a bipartisan effort with the support of the administration?
I believe so.
Okay, so got it. So this needs to be
Go to finance.
okay. There is a request that it be that the motion be reported and refer to finance. That motion was made. Was there a second?
Second.
Okay. Let's vote on the voting board.
Ayes 15, no zero.
Okay. Senator Reeves, did you have? Oh, I'm sorry. Oh, okay. Well, I was trying to be fair and go back and forth. If you have to leave, we could take you first.
It's your committee, Mr. Chairman.
I was going to work in bipartisan. Okay. Senator Reeves, are you prepared, or do you want to go back to Senator Rouse?
Mr. Chairman, the senator would like to, she needs to go somewhere, so she was
Oh,
hoping she
Senator
could do a
Craig.
bill real quick.
Okay. Senator Craig, why don't we take yours then if you, okay?
There we go. All right, did we take care of the 809 while I was gone? Okay, thank you.
Yeah. So we're at 808?
Yes. And 807,
Oh,
we'll do
807.
807 first. All right, 807, this legislation is amending the Real Estate Timeshare Act, offers key benefits for both consumers and timeshare resellers by enhancing privacy protections and reducing liability. By removing the requirement for resellers of to retain certain copies of government-issued photo IDs, the risk of identity theft is minimized. The resellers are relieved of the burden of safeguarding sensitive personal information. Basically, right now, they have to keep the photo IDs on file, and this is just stating that they do not have to do that any longer. And I believe copying a military ID is against the law, I believe, or.
Okay, so no one would have to keep a photocopy
They would not
of
keep
a
the, they would
driver's
not keep
license or
the
military
IDs.
ID in a timeshare
Yes.
transaction. Okay, then are there any questions for Senator Craig? Anyone who's wanted to weigh in on this bill in the audience?
Those online who wish to speak, please raise your hand.
Okay, there was no testimony on this bill? Okay. Senator Craig, where'd this bill come from? This came from the...
I just put it away. Hold on for a second. I thought y'all were going to pass it real quick.
Okay, well, I just want to make sure... And
I was getting excited. It's DPOR.
Okay, from DPOR. Okay. Was there a motion? Move to report in a second. So express your preference on the voting board. Okay, and Senator Craig, you had another bill on the Resale Disclosure Act?
Oh, I did. Sorry about that.
Ayes 15, no zero.
Thank you.
Okay.
All right, I have Senate Bill 808. This bill was brought to me by the Virginia Realtors and seeks to make a small change in the resale certificate that is ordered in real estate transactions that occurs in a common interest community. As part of the resale certificate, a common interest community is already required to disclose to a prospective buyer a statement describing any insurance coverage provided by the association for the benefit of the owners, including fidelity coverage and any insurance coverage recommended or required to be obtained by the owners. Senate Bill 808 seeks to add to this section of the resale certificate a statement that would make a prospective buyer aware that the governing documents of the association may make an owner responsible for the association's insurance deductible in whole or in part when a claim is made against the policy by the owner. This change requires nothing additional from CICs. It is merely a statement added to the resale certificate. The stakeholders are in agreement, and I have Aaron here with the Virginia Realtors to speak on this bill.
For comment?
Yes, I just want to thank the senator for working with us on this bill. It's something that we brought to her, and I'm happy to answer any questions about it.
Okay, are there any questions for Aaron or for the senator? Yes, Senator Williams-Graves.
Is that a common practice in condos where, or associations where there is a master policy and the owner of the property has to pay the copay?
So it's not necessarily it's not the copay or the premium, it's the deductible. And from my research, and I don't know if there's anyone from CIC here, but maybe like 50%. It's usually somewhere in the governing documents. Just as an example, we had a member come to us that had damage in their condo unit from a pipe bursting. They went to their homeowner's insurance, and the homeowner's insurance said, you have to go to the condo because it's the internal pipes. The condo association said, no problem, we'll make the claim, but you have to pay our deductible, and it's $20,000. And they just had no way of knowing that that was even a possibility. And we just want to flag it for them so that they know to check the governing documents ahead of time to find out if they might be one of those associations that makes them responsible when a claim is made.
Follow-up question, Mr. Chair.
Yes, Senator.
Is it possible to amend to include that the amount of the deductible has to be disclosed as it stands at the time that the resale disclosure certificate is issued to the potential buyer? Because it's you're giving us $20,000, and that's a whole lot for somebody to buy a condo and not know that they may be on the hook for.
Mr. Chair, can I? So that is something that we considered, but after having conversations with a lot of common interest communities, the fact-finding process that goes into that is different in every single community. So the overall deductible may be $20,000, but after fact-finding, they may find that 4 different units were damaged, and one of them was primarily responsible for the damage, and so the amount that they would be responsible for may be different in every situation. And that's why we felt like it was the best way to do it was just send them directly to the governing documents where they could see what that policy was and what the fact-finding process was to determine how much they would owe. But it's going to be different in every situation based on the facts of the claim being made against the policy.
Thank you. Okay. Any other discussion or anyone in the audience or in the online world who wants to comment?
Online who wish to speak to the bill, please raise your hand.
Okay.
Move to report.
Okay, there's a motion to report and a second, anyone?
Second.
And a second. Okay. All in favor, please indicate your preference on the voting board, and those opposed do the same.
Ayes 15, no 0.
Okay. Great, thank you. Okay, and then I'm going to turn to this side. Who's next? Senator Rouse? Okay.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. I have 2 bills. We start with the SB 972 first. And this is the Good Friday bill, which, if you recall, a number of years ago, a naval jet crashed in the city of Virginia Beach near a residential area, and no one was hurt. Yeah. So that's why this is called the Good Friday bill. But we understand that a lot of our first responders were exposed to toxic materials. And so last year, we passed legislation for a work group. And this is the result of the Department of Fire Programs work group authorized by the General Assembly last year to develop criteria for a grant program that would support government employees who respond to emergency situations where toxic materials are present. The work group met throughout the summer and included members from emergency management, planning, and budget, Treasury, VACO, and VML, state and local fire, EMS, police association, and members of the local government. And this bill will create a critically important grant program that supports government employees who respond to disasters where toxic materials are present.
Thank you. And this is a result of the work group, that the study group, and because it has a fiscal impact, the motion would be to report of finance.
Yes, Mr. Chairman.
Are there those in the audience who wanted to speak in favor of this bill briefly?
Those
Okay,
online who
please
wish
come
to
forward.
speak to the bill, please raise your hand.
Good afternoon, Mr. Chairman, members of the committee. We'd like to thank Senator Rouse for his leadership on this issue. I'm Brent McKenzie from the city of Virginia Beach, where the initial event that led to this grant program happened. We really would appreciate your support for this. Thank you.
Thank you.
Mr. Chairman, members of the committee, Jennifer Pike with the Virginia Professional Firefighters, and we support this legislation.
Thank you.
Good afternoon, Devin Cabot on behalf of the Virginia Fire Chiefs Association, and they support the bill.
Thank you. Okay, is there anyone online? Okay.
Move to
So
report.
there's there's a move to report and refer to finance, a motion, and a second, and we'll indicate our preference on the voting board.
Ayes 15, no 0.
Okay, and Senator Rouse,
Yes.
that passes
I have one.
unanimously, and we've got another bill from you.
Yes, Mr. Chairman, I don't know if this will meet the same fate, but I remain hopeful. We have SB 812 in front of us, Mr. Chairman, and this bill is considered a need for today. It would extend the pay or quit notice period from 5 to 14 days, giving tenants more time to catch up on rent before a costly eviction lawsuit is filed. This 14 days gives tenants more time to get another paycheck. This was looked at specifically, the 14 days was looked at specifically for tenants to get another paycheck or borrow money or get access to rental assistance to be able to stay in their homes. Eviction lawsuits drag tenants into debt. and everyone is better off when an eviction lawsuit can be avoided, because once it's filed, obviously court costs and attorney fees are also tacked on to what the tenants already owe. Mr. Chairman, we should try to do everything, and members of the committee do everything and use every tool available to keep people safely housed. And it's interesting to note that Virginia has among the highest eviction rates in the nation. The need is clear for better solutions for tenants to avoid being evicted. And Mr. Chairman, I know we want to be brief, but I took it upon myself to just look up some homelessness rates that are on the rise, specifically in Central Virginia. Here in the city of the Richmond region, the older population accounts for 44% of the homeless race. That is an increase of over 20% from 2023, Mr. Chairman. And also looked at from the Virginia Housing Alliance, the housing cost burden. 1 in 3 Virginia households are cost burdened, which means that they spend over 30% of their income on housing. Mr. Chairman, 83% of renters earning up to 30% AMI are cost burdened. And lastly, Mr. Chairman, 347,000 Virginians qualify for housing choice vouchers, but only 1 in 5 households who qualify for the vouchers receive and use them. And here in Virginia, there are 153,385 affordable rental units that were developed through public assistance, such as Housing Trust Fund or the Low Income Housing Tax Credit. Mr. Chairman.
Thank you, Senator. This is the same bill as we passed last year through this committee and through the Senate on a divided vote?
It is, Mr. Chairman.
Okay. So is there anyone who's not familiar with the topic or who has questions for some of the people who want to, you can weigh in, but I want to know if any of the committee members have any particular questions first. Okay, well, let's hear your testimony.
Thank you, Mr. Chairman. Christy Mara with the Virginia Poverty Law Center. And Mr. Chairman, members of the committee, I did just want to clarify that the form that this bill is in, and we do support it, and I have a few comments on that, is identical to the floor substitute that you all passed last session, and that was subsequently vetoed by the governor. So I think it was a little bit different. It was different from what was in the committee. So I just wanted to make that distinction for everyone. But I do believe that passed pretty strongly from the Senate.
Thank you for the clarification. Okay, there seems to be a line of folks. Why don't you get closer, and if you could be brief, that'd be helpful.
And thank you, Mr. Chairman. As I said, I'm Christy Mara with the Virginia Poverty Law Center. We have for years advocated that the pay or quit period, as we call it, should be extended to 14 days, which is what this bill does. And what that means is tenants will have more time, 9 extra days to be specific, to pay their rent before they are sued. And that's really significant. This last year in 2024, there were over 138,000 eviction cases filed in the state of Virginia. And what that means when somebody can't pay their rent on time, can't pay their late fee before they get sued, is that now that tenant also owes court costs and in almost every circumstance, significant attorney's fees. And what that means for landlords is that they paid out of pocket those court costs and those significant attorney's fees. And so by giving people time to get another paycheck, or by giving them time, if they don't get a paycheck, to go ahead and successfully get help from a local organization that has, for example, Virginia eviction reduction funding, they're able to avoid going to court, avoid those extra fees, and significantly prevent the landlord from having to go to court and pay those extra fees. So we see this as a win for both sides. We don't agree that it's going to cause tenants to want to pay late. Tenants still want to avoid that 10% late fee. And that 10% late fee is the same whether they have until the 5th day to pay it or the 9th. It does not go up. So nothing in extending the pay or quit time causes the tenant to pay any more money. Nothing in that extension puts them further in debt. And we strongly believe that it helps them pay that debt and pay it fully before they have to go to court. And we ask you to vote yes on this bill and advance it. Thank you.
Welcome.
Hi, Chairman Laura Dobbs with Housing Opportunities Made Equal, and I'll align my comments with the previous commenter and we support the bill.
Thank you.
Mr. Chair, Isabel McLean with Virginia Housing Alliance, and we also support the bill.
Thank you.
Mr. Chair, members of the committee, Jeff Caruso with the Virginia Catholic Conference. I just want to add that we checked with our Catholic charities agencies, and they've told us that this bill would be especially helpful to the people that they serve. And that's for two reasons. One, it would give them a few extra days to try to pull together the funds for the people they're trying to help. And secondly, as you know, many people get paid every 2 weeks. Thank you.
Thank you.
Afternoon, Chairman. Chad Stewart with the Virginia Education Association. The reason we're supporting this bill is because our educators are frontline for seeing the effects of housing insecurity on students every day and how that affects their ability to form long-lasting and trusting relationships with educators. So our members have identified this as a promising bill to give families a reasonable accommodation to prevent evictions and keep housing insecure students in schools for longer. So we ask you to support the bill.
Thank you.
Mr. Chairman and members of the committee, Kashish Pillay with New Virginia Majority and Allies for Housing Action. It's a housing coalition statewide comprised of state and local organizations. We represent renters across the Commonwealth, and we support this bill. Thank you.
Thanks. Okay, and I guess the opponents are over here. So come close, and if you can, brevity is appreciated.
Thank you, Mr. Chair. Erin Corman with the Realtors. I just want to clarify the bill that passed out of this committee last year. The bill that we all had come to consensus and compromise on is not the bill that passed the full House. So there was a compromise in that bill that was stripped out. So at this point, this bill is back to pre-compromise language, and because of that, we do oppose it. A few years ago, we did come to an agreement, and there is basically an unlimited right of redemption in the code that lets a tenant pay up everything they owe anytime prior to the court date. If they can't come up with the money by then, because I understand they don't want to have to go through the court process, but if they have to, they can still pay all the way up to 48 hours prior to the eviction. So there are many opportunities for them to pay if in the off circumstance something were to happen, meaning that they would have to wait till that second paycheck. So we currently oppose this measure as long as the right of redemption is still active in the code.
Thank you.
Thank you.
Mr. Chairman, members of the committee, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We agree with the comments that were just stated. The compromise from last year is something that we worked really hard on, and unfortunately, this year we're not going to be able to agree to that. But there are a lot of unintended consequences with this legislation, especially since we're drawing out the full eviction process to between 2.5 to 3.5 months. And this was implemented on an emergency basis during COVID at a time where we had the rental assistance program. And so, the emergency is lifted. We do not have that program anymore. And then, we do want to make sure that folks know we have worked on several pieces of legislation to make it easier for tenants to, come and pay and get rid of that eviction. Like Aaron mentioned, that unlimited right of redemption is in place. They can pay 48 hours before and wipe the slate clean. And last year, we actually passed a bill. It was HB 73. So now tenants' records are automatically expunged altogether when an unlawful detainer does not result in an eviction. So, we are putting measures in place, and we ask that you strongly oppose this bill. Thank you.
Thank you.
Mr. Chair, members of the committee, Zach Lemaster here on behalf of the Northern Virginia Apartment Association, and we oppose the bill.
Mr. Chairman, ladies and gentlemen of the committee, my name is Brian Horn. I'm the Director of the Department of Housing and Community Development. As been mentioned, this was a subject of the governor's veto last year, and for the reasons cited for therein, we respectfully oppose the bill.
Thank you. Okay. And we have one person online. If you could unmute yourself and show yourself on camera, you have 1 minute.
Jordan Cruzmel, please turn on your camera and unmute your mic.
Good afternoon, Senators. My name is Jordan Crowham. I'm the program manager of the Virginia Eviction Reduction Pilot at 4Kids. We're here in Chesapeake, Virginia. I'm a Norfolk, Virginia resident as well, so great to see my senator here. And we want to thank Senator Rouse for supporting this bill and sponsoring this bill. I personally work with folks who are facing eviction every day, and I see the hundreds of dollars of largely unnecessary fees that are caused by evictions that they are planning to pay. And so when we look at ledgers and when we look at these things, we're talking about hundreds of dollars for renters who can least afford it. As it was mentioned earlier, our eviction rates are among the highest in the country. Largely in our jurisdictions, we see that between 50 and 60% of those cases are dismissed. And so we think that we can do a great service to our courts and our tenants by extending that paraquet timeline before these cases are filed. And we urge you to support this bill. Thank you.
Okay, so the bill is before us. People are familiar with it. It's the version that passed the Senate last session. Is there a motion?
Second.
Okay, there's a motion to and a second to report. So let's vote on the electronic voting board.
Ayes 9, noes 6.
Okay, the bill passes. Senator Rouse, was that your last bill?
Yes, sir.
Okay. Before I turn back to Senator Locke, is there anyone here who's going to have to leave in the next few minutes? Okay, let's. You what? You want to go next?
No, I'm going next, but I'm going down there because I want them to face.
Okay, Senator Locke is going to speak from the podium and present, and then we'll take anyone else. Is this the Eviction Diversion Pilot Program? Okay, so Senate Bill 830.
And that's going to finance.
This is, and this bill has been requested by Finance, so the motion would be to report and refer. But Senator, go ahead.
Next one.
Okay. Senate Bill 830 comes as a recommendation of the Housing Commission. We initially had an eviction diversion pilot program that worked very well at preventing the eviction of tenants who used the program. And what Senate Bill 830 will do is expand and make permanent the eviction diversion court program within the General District Court to make it available to any locality that wishes to participate. Note that wishes to participate. And the program should be made permanent as it serves as an effective tool to reduce the number of evictions in the Commonwealth. Evictions are trending toward a return to pre-pandemic levels in many Virginia localities, and the court program will help prevent some of these evictions, and that's what this will do.
Thank you, Senator. So this is a program that's in existence today.
It came into existence as a pilot in 4 localities.
In 4 localities that would expire in July, and this would remove the sunset and make it available to others?
Yes.
Or to all?
Yes.
Okay. Are there questions for Senator Locke before we hear testimony from witnesses? Okay. Those in support in the room, please come forward.
Those online who would like to speak in support of the bill, please raise your hand.
Hi.
Good afternoon, people. Elizabeth Pollan, Director of Virginia Housing Commission. I just have a couple statistics. There was a 75% increase in program participation in the first half of 2024 compared to the entire year in 2023. The localities that are using this program are seeing success rates with this program. There's an 85% success rate, which is very high in cases that resulted in executed writ of eviction.
So we're seeing people remain housed and landlords getting paid.
They are. It's a pretty tight list of qualifiers in order to participate in the program. You have to pay a certain percentage of the rent that's due, and you have to show that you will be able to pay the rent in a certain amount of months of time. In addition, you cannot have used this program. It cannot be a continual fix. It's basically you have some sort of medical emergency, you have two jobs, you lose one of them, it allows you to, the court to offer an alternative to those that fit those qualifications that will be able to pay, but for right now cannot.
Okay, thank you for your testimony and for your work. Why don't you come forward?
Chad Stewart with the Virginia Education Association. For reasons similar to the previous bill, we also support this bill.
Thank you.
Erin Corman with the Realtors. We support the bill.
Thank you. Okay, and you had another something to say?
I'm sorry, I just forgot to add that there is no fiscal impact to this bill. We checked with the Executive Secretary of the Supreme Court, and they told us there was not a fiscal impact.
Because Finance has requested it, they'll review it. Sometimes they get overzealous, but Senator Locke will be there to shepherd it through if that's the case. Okay, was there anyone who's opposed to this bill in the room?
Those who wish to oppose the bill online, please raise your hand.
Move to report. And re-refer to finance.
Okay, so Senator Rouse moves to report and re-refer to Finance, and Senator McPike seconds that motion. So we'll, unless there's more to say, we'll vote on it.
Ayes 15, no 0.
Okay, Senator Locke, you had another bill.
I'd like to move to Senate Bill 777.
Sounds like a lucky number. Okay, and this one has also been requested by Finance. This is about a low-income energy efficiency and weatherization report.
Yes. There's a group called the Climate Equity Working Group, and they have been working on issues dealing with efficiency, and they are proposing to establish a one-year task force to do three things. One, evaluate the accessibility of energy efficiency resources for low-income households, identify key barriers hindering energy efficiency retrofit and weatherization efforts, and develop actionable solutions to enhance energy efficiency in low-income households. And the reason for this is because high utility bills are forcing Virginians to choose between essentials like groceries and medication and keeping their home at a safe temperature during hot summers and cold winters. And households are being burdened or being energy burdened. And so a high percentage of income is being spent on utilities. An energy burden higher than 6% is considered unaffordable. Virginia has the 10th least affordable residential energy bills in the country, where over 75% of Virginia households have an energy burden higher than the 6% affordability threshold. So this particular legislation says that weatherization repairs and energy efficiency upgrades can help households reduce their energy burden and improve health, comfort, and safety. There are estimated to be over 150,000 low-income homes in Virginia that are good candidates for retrofits. So this bill is necessary because energy efficiency providers, state agency, and advocates have been working tirelessly on this issue for years, but we need a more dedicated approach and prioritization from the Commonwealth to fully succeed. So without a legislative stick, the status quo is likely to continue, which doesn't come close to solving energy burden concerns for residents of the Commonwealth. So Virginia needs to require data sharing from utilities and state agencies, a dedicated workforce development plan to meet the unmet need, and a push from across the board to make this happen. So that is the purpose of this legislation.
Thank you. So I think we're clear about what the work of this task force would be. Are there those in the audience who wanted to weigh in support?
Those online who wish to support the bill, please raise your hand.
Okay, come forward and perhaps you could have like a spokesperson and maybe indicate your agreement or something, or a spokesperson or two.
Thank you, Senator. Ben Hoyne, Climate Equity Working Group. I think there is a substitute, but we are here in support of the bill.
Mr. Chairman, there is a substitute for Senate Bill 777.
Move the substitute.
Okay, the committee substitute being distributed has been moved and seconded. All in favor, say aye. Aye. Any opposed? Okay, so Yeah, if others who want to address the substitute, please let us know. Is there, are you there to indicate your support? The folks standing up, did you want to, others want to come forward, just say their organization or anything more that is compelling to us?
Thank you, Senator. Again, Ben Hoyt, Climate Equity Working Group. All the substitute does is change the word low income to income qualified. It extends the task force work from 12 months to 15 months. And it eliminates any specific non-governmental organizations from being listed in the bill as part of a task force and moves it to more generic terms. So Climate Equity Working Group supports the bill, as do many others.
Thank you.
Mr. Chair, members of the committee, Blair St. Ledger Olson with the Virginia League of Conservation Voters. The most affordable energy we have is the energy we don't have to use, and for that reason, we support the bill. Thank you.
Thank you.
Good evening, Mr. Chair. I'll be brief. I'm Twyla Mathias, Progress Virginia, and we're a member of the Climate Equity Working Group also, and we support the bill. Thank you.
Thank you.
Good evening, Mr. Chairman and members of the committee. My name is Tanisha Griffin. I'm the Environmental Policy Analyst at New Virginia Majority. We're also a member of the Climate Equity Working Group, and we support the bill as well. Thank you.
Mr. Chair, members of the committee, Peter Anderson with Appalachian Voices. We want to thank the patron for her work on this incredibly important issue. We support the bill. Thanks.
Mr. Chair, members of the committee, Victoria Higgins, Chesapeake Climate Action Network Action Fund, and we also support the bill. Thank you.
Mr. Chairman, Andrew Clark with the Home Builders. We are not a part of the climate group. May be convinced pretty soon, but we support the bill fully. This is a big issue in Virginia. I think the number is 55% of Virginia's housing stock was built between the 60s and the 90s. This is desperately needed in rural, urban, suburban areas, and appreciate the senators bringing it forward. Thank you.
Mr. Chairman, members of the committee, Senator Locke. Again, Carmen Bingham with the Virginia Poverty Law Center, and we also are not part of the Climate Energy Working Group. However, we do appreciate this legislation as it brings forth the issues that we've been working on through other coalitions and collaborations on energy efficiency programs in Virginia. First with the Energy Efficiency for All Virginia Group, which used to be the Multifamily Energy Efficiency Council, and also the 2018 GTSA enacted stakeholder group, energy efficiency utility stakeholder groups, which have been working on energy efficiency programs and improving them for constituents here in Virginia in those two service territories. We believe that this task force that this bill creates will actually address the issues that we are right now facing in those work groups, which is the implementation of these programs. So we support the bill. Thank you.
Are there any more opposed to this five piece of legislation?
Those online that wish to oppose the bill, please raise your hand.
Okay, so there's a motion. Senator Williams-Brigham has a question.
Thank you, Mr. Chair. Senator Locke, in the work group, does it just include homeowners, or is there also an opportunity to include landlords who have like older properties that need to be weatherized to help their tenants save on utility bills?
Let's see. It says that the task force members will be selected. There's 12 non-legislative members of the Commonwealth, including at least, it specifies in the bill that who the 12 non-legislative members will be. I don't think it specifies. It
talks about income qualified individuals for households,
right,
but it doesn't preclude anyone who doesn't.
Right.
Right, and I'm just trying to get them included because a lot of times, Mr. Chair, Senator Locke, those are a lot of the people that we see who have these issues, and it's not their property. So that's the thought process there, to help include those folks.
It talks about multifamily buildings on line 69, so manufactured homes among others. Right.
Okay.
Yeah, single family dwellings.
Okay.
Right.
Not called out specifically, but certainly remember that there's
Okay.
the task force.
Thank you.
Any other, unless there's other discussions or vote?
Ayes 15, no 0.
I have one more. And there's also a substitute for this bill as well. Okay, and the reason for this substitute is to simplify language overall, to give more clear guidance to DHCD, and it directs DHCD to consult necessary stakeholders to administer what I'm going to talk about as the pilot program, and it includes a priority to partner with specific liaisons to administer the program, and it gives flexibility to use funds for housing assistance more generally, not just rent. And it changes the word voucher to make it more clear what is exactly meant by that. There were several of us who met a few times to talk about this rental assistance pilot program. And it generally is talking about 5,000 families to invest in the future of Virginia students and families by providing what we call rent relief. The pilot program will provide $80 million in rent relief over a 3-year period to 5,000 low-income families with school-aged children and younger 5,000 school-aged children across Virginia. For the purposes of this program, rent relief will be provided to families on a monthly basis to keep their housing costs affordable for the long term. Qualifying families make 50% of the area median income and include at least one member 16 years of age or younger. This money will be spread across 3 years for this pilot program. This is a relatively small investment in comparison to Virginia's statewide budget and will have an outsized impact for students, low-income families, and the Commonwealth as a whole. If we want all Virginia students to be successful, we need to invest in housing opportunities that support them. This program will empower 5,000 families and their children by ensuring that they have a stable home and thus a strong foundation for success at school and beyond. All parents want to provide a better future for their children, and this pilot program will help qualified Virginia families provide a safe and stable home for their children, setting them up for long-term success. And we need to think about this beyond just housing. We need to also think about it in terms of education and stability for these families to ensure future success.
Thank you, Senator Locke. Okay, so we have a substitute before us. Are there folks in the audience who want to weigh in support?
Those who would like to speak in support of the bill online, please raise your hand.
Yeah, I think that Senator Locke was pretty clear about the program. My only comment would be, while the goal is 5,000 families, if it's funded fully, it could be perhaps less, depending on what Finance Committee were to do with it. But if you want to share anything you find compelling, please do so. Otherwise, just indicate your support.
Mr. Chairman, I'll try to be brief. Isabel McLean with Virginia Housing Alliance. We thank the Senator for working with us and for introducing this bill. Of course, we support it. I will also just point out briefly that this program will start to address the significant unmet need that left behind by our federal program, but it will not duplicate that federal program. DHCD will have the flexibility to have comparably less administrative burden, remove certain barriers to access, and create new pathways for families to access assistance. So we request you support the bill.
Thank you.
Chad Stewart with the Virginia Education Association. Our association is fully signed on and supportive of the 5,000 Families Initiative. We especially appreciate that this is targeted towards families with school-aged children, and we see really important benefits for those families in keeping kids in stable schools all year round. Thank you.
Thank you.
Thank you, Mr. Chair, members of the committee. Scott Pedowitz with the Apartment and Office Building Association and Virginia Apartment Management Association. This program is a terrific step at helping families to meet their obligations and remain in their housing. We thank the patron for bringing the bill and encourage the committee to support it. Thank you.
Thank you.
Christy Marrow with the Virginia Poverty Law Center, and we thank Senator Locke for bringing this bill. As everyone has stated, this is really a critical program to start to serve especially these families with school-aged children. We know from studies that have been done in the past that getting children stable housing and letting the family have the means to get the housing of their choice when children are young helps them stay in school, helps them learn, and helps them have long-term better educational and income outcomes for their lives. So thank you.
Thank you.
Hi, Laura Dawes with Housing Opportunities to Be Equal, and we enthusiastically support the bill.
Thank you.
Mr. Chairman, members of the committee, Zach Lemaster with the Northern Virginia Apartment Association, and we support the bill.
Thanks.
Kashish Pillay with New Virginia Majority and Affordable Allies for Housing Action, and we strongly support this bill. Thank you.
Thanks. And we have, are you for? Or okay, we'll wait for you 1 sec. Okay, and we have, before we go online, let's have those who are opposed or have questions. Why don't you come forward? Yeah.
Thank you again, Mr. Chairman, ladies and gentlemen of the committee. While we appreciate the intent of this bill, we're concerned that it would have the effect of increasing demand as opposed to supply, and we have a serious supply problem. And for those reasons, we would respectfully oppose this bill. Thank you.
How would it increase demand to help kids at risk of homelessness stay in their dwellings or find dwellings?
By providing resources, it would have the effect of not addressing the actual supply problem that we have.
Okay, thank you.
Thank you.
And then online, if you could keep your comments to a minute and unmute and show yourself on camera.
Miss Jessica Amaya, please unmute and turn on your camera.
Hi, thank you for allowing me to be present and to contribute today. My name is Jessica Amaya Jimenez, and I'm here as a parent and lived experience leader to share why SB 832 is vital for families like mine. In my youth, my family experienced homelessness for 6 months, making school attendance and success nearly impossible during that time. The stability I longed for then as a child is what I strive to provide for my own children today. My 33-month-old toddler and my 9-month-old baby do not have that long until they're going to be in school. And unfortunately, due to unexpected family crisis that resulted in further unexpected job loss and an insensitivity of an employer, my family is now facing financial difficulties. Despite being in a safe environment, the struggle to keep up with rent is what jeopardizes our ability to maintain that stability. Stable housing isn't just about a roof over our heads, it's about giving children that secure foundation that they need to thrive in school and in life. The 5,000 Families program would provide rent relief that could be the difference between kids having that stable base to even attend school or further falling behind in their development due to homelessness or instability. This modest investment will help build stronger futures for children, empower families, and benefit our community as a whole, and I urge you to support this critical program. Thank you.
Thank you for your testimony. Okay, there's more online?
Jordan Crossmo, please unmute your mic and turn on your camera.
Good afternoon again. We are reported as 4 kids here in Chesapeake. We work with families every single day with school-aged children who are experiencing homelessness in our region, who are facing rising rent costs. And this program like this would help those families stay housed, but also get housed when they're facing those insecurities. And I'm literally looking at our teen program for school-age youth over the left side. If you see me look over there, I hear them. And those are the kids that we do it for. And this is what 5,000 Families is seeking to say, is those families are worth our support and they are worth having stable and supportive housing. And so we think 5,000 Families is an excellent step towards that. Thank you.
Thank you for your testimony. And we have another.
Lenore Grant, please unmute your mic and turn on your camera.
Good evening, I'm Chairman and the Senate. My name is Lenore Grant. I'm strongly in support of this SB 832 program. Being a mother with a middle schooler who experienced homelessness to a domestic violence situation. I had to spend over $50,000 just to keep us safe, to stay in a hotel, as mentioned previously. Some people can't do that, and as well as knowing that I was a temp worker.
Can you turn on your camera?
Oh, I thought it was on. I'm so sorry. Can you see me now?
Not yet.
Okay, there it goes. Could you hear me?
There you are.
Okay. Yes.
You can see me now. I'm sorry about that. This bill is just very crucial. The mental aspect that it has on the children is just really, really bad. As I stated, I paid over $50,000 to live in a hotel to keep my child safe. Not only for this program is important. I mean, the graduation rates will be higher and everything. So thank you so much for listening, and please, I support this program. Thank you.
Thank you. Okay, I believe that concludes our testimony. Are there any questions of Senator Locke or discussion before we proceed to vote?
Do we have a motion yet, Mr. Chairman?
Move to report and re-refer to finance.
Second.
Okay, we have a motion and a second to report and re-refer to finance.
With the substitute.
As substitute as adopted. Let's vote on the voting board then. Okay.
Ayes 9, noes 4.
Thank you, Mr. Chairman.
Thank
That
you.
completes my bills.
Okay, I think Senator,
Really easy.
Senator Reeves, we're gonna test how easy it is, but you go first and then Senator McPike will go.
Mr. Chairman, I have Senate Bill 866 brought to me by the Virginia Realtors. What this bill does is seek to increase the amount and type of real estate experience on the real estate licensed member of the real estate board at DPOR. It changes the number from 5 to 10 years in the legislation. The reason they are doing that is they've had people appointed to the board that didn't have the experience or the work ethic. That board reviews every education instructor, every course, including its curriculum, the license applications, and adjudicating all violations for real estate. It increases, like I said, the years of work experience. Not all of the real estate licensees who work in real estate work full-time. It also adds additional experience requirements for licensed board members, including real estate credentialing, certification by the real estate board as a real estate instructor, or training experience in adjudication of other real estate licenses. Finally, the bill would require that at least one licensee member of the board have experience in residential property management. It's the Realtors' hope that this will provide a more experienced and stronger real estate board. Erin is here to speak to the bill if we need her.
Move to report.
Okay, there's a motion and a second to report 866. Is someone from DPOR here at all? Okay, you don't see any problem with these increased expectations for a strong real estate board, do you?
Mr. Chair, Steve Kirshner from DPOR. We have no position on the bill.
Okay, but I'm assuming the realtors don't think Erin, we're going to be able to still get enough applicants for the board with these additional qualifications, right?
I have no concerns about coming up with applicants that meet these requirements.
Okay, thank you. Okay, so there's a motion to report and a second, I believe. Okay, so we can vote on 866.
Ayes 10, no 0, 3 abstentions.
Okay, thank you. Okay, then, what? Well, now we get to Senator McPike, and then we'll come back to you and Senator French if you have any.
Thank you, Mr. Chair. Senate Bill 1309, and I do have a substitute to offer.
Move substitute. Okay, there's a motion and a second to adopt a committee substitute for 1309, which is being distributed. All in favor, please say aye.
Aye.
Okay, any Opposed? Okay, the substitute is before us. Senator McPike, if you could describe the bill with any emphasis on significant differences between the substitute and the original bill.
Yeah, thank you, Mr. Chairman. So the bill makes, the difference in the substitute is really changing from an affirmative statement versus a negative. And so materially, the substitute before you is the same. And so Senate Bill 1309 requires real estate licenses working with buyers and tenants to have a written agreement prior to showing property. Current law does not require this, so long as licensees just opens the door and lets the person walk around, but does not answer any substantive questions about the property. And the written agreement prior to showing the property protects both the consumer and the licensee by establishing upfront expectations of what all the obligations are with all the parties involved. So that's essentially the bill. Aaron Corman is here with the Virginia Realtor as well to answer any questions.
Vote on the motion that's been made to adopt the, to report, we adopted the substitute. But before you vote on reporting it, I just want to ask Erin from the Realtors if she wanted to comment at all.
I'm happy to answer any questions, Mr. Chair. Just thank the senator for working with us on this bill. I think it's an important consumer protection, so.
Okay, thank you. So we can have vote on that motion now on SB 1309.
Ayes 13, no 0.
Okay, we got 1310 dealing with architectural requirements to be an architect.
Yeah, thank you, Mr. Chairman. That's exactly right. Senate Bill 1310 essentially introduces a process where someone who's been serving in, for instance, in an architectural firm or other context and working but does not have a license. We're trying to get more folks into it, so it applies essentially the 10 years of work experience plus other coursework, as well as exams to get that. And so it sets up a process for a person to apply and through the, sort of the DPAR process, allowing them to establish what some of those benchmarks would be. I do have a few line amendments to offer, and amendments, I think we have some copies, but I can quickly read them, Mr. Chairman.
Well, why don't you read them as they're being distributed if there are copies for members?
Absolutely. So line 22 after.
Oh, wait, let's have council read them, if that's okay.
They can do that as well.
Mr. Chair, the amendments read as followed. On line 22, after licensure, strike under this section and insert to certify worked and education experience.
And that's it.
And Mr. Chairman, I have one other amendment that council, which is from line 23, starting with such applicants, through the rest of the sentence would be to strike that. Essentially, under lines 18 through 21, it sort of already stated that the process which they would establishing process for the work and education experience to qualify, so it's sort of duplicative and not needed under section B. So they're already going to go through the process to establish what the experience is.
Okay, so is that clear, or do you need that?
I got a question.
Go ahead.
So, Mr. Chairman, Senator McPike, is this in lieu of, say, someone who's been in the industry for like 20-some years, they have the experience of working, but then have the architectural license? Is this what they're trying to get at?
Yeah, Mr. Chairman, I answer the senator, yes. It's essentially, right now, they're not eligible to be a licensed architect, but they've got the years of experience. They can sit for the test, everything else, but they wouldn't qualify under our current rules. So this allows DPOR to establish those criteria, implying work experience. They could also have coursework and a combination thereof to apply to get licensure within the Commonwealth of Virginia. And so I would move the amendments.
Okay, so first we're going to vote, they've been moved in second, and first we're going to vote on that set of line amendments on lines 22, 23, and 24. All in favor signify by saying aye.
Aye.
Any opposed? Okay, and then Senator McPike, on line 20, it says education experience to the practice of architecture. Would it be friendly amendment to change that in the practice of architecture, just grammatically, or I don't know why it says experience to the practice at the end of line 20.
Mr. Chair, I'd rely on council. This has been through editing, so.
Council, is that the way it should be? Experience to the practice?
We can make that grammatical change.
Okay. Do we need to vote on that, or is that just something that they'll pick in editing? Or We should vote. Okay, so the side proposed to amend that, the word "to" the word "in" on line 20. Is there a second? Second. Okay, so all in favor say aye. Aye. Any opposed? Okay, so that's adopted. So now we have the bill before us, which is basically allowing practical experience to apply toward architecture. This doesn't eliminate any qualifying tests. They'd still have to take the test to become a licensed architect.
Mr. Chairman, that's right, that you still have an architecture registration exam, you still have architectural experience programs that would apply to it. It's really about the combination of education of formal, whether it be bachelor or master's. So this allows the combination of experience, still going through the same exam, but the end goal is getting additional licensures, licensed architects.
And I understand this is supported by the American Institute of Architects?
Yes, Mr. Chairman.
Okay. And does DPOR have any comment on it or a position? No position. Okay. So are there any witnesses who are compelled to speak? Okay.
Move the report as amended.
Okay. There's a motion, a second, to report as amended. All in favor, please indicate your preference on the voting board, and those opposed do the same. Okay,
Ayes 13, no 0.
Thank you, Senator McPike. I think, who was next? Is it me or Senator, I'm sorry, Senator Head. Okay, please.
Thank you, Mr. Chairman. I have Senate Bill 795. This is to establish the Virginia Museum of Transportation as a state agency. This is, we'll have to go to finance if the committee acts favorably on this. Museum of Transportation is already officially by resolution the official Museum of Transportation for the Commonwealth. This just would make it a state agency and would facilitate them being able to have better access to things like certain rail lines that are owned by the Commonwealth to run the 611 steam engine on for excursions. So,
and is this identical to a bill that we passed unanimously from this committee last year?
It was actually not this committee, it was out of the Education and Health Committee, but it did pass unanimously out of that, yes.
Okay.
Last year, so.
So I think it's been well explained. Is there anyone who feels compelled to weigh in briefly?
Move to report and re-refer to finance.
Second.
Okay, there's a motion and a second to report and refer to finance. Let's vote.
Ayes 13, no 0.
Okay, and is that's it for you today? And Senator French, you didn't have anything today. Okay, and then I've got a few. I'm going to turn it over to Senator McPike to preside while I present from over there.
So, Senator, you want to start with Senate Bill 1042?
Yes, please.
All right, and if that reports, it needs to go to finance.
Okay, so 1042 has a line amendment on that changes one word on line. Is it 387? Striking the word 3 and inserting the word 5.
All right, there's a motion. Is there a second on the amendment? There's a motion, a second. All in favor of adopting the amendment, say aye. 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 The amendment is properly before the committee. So.
Okay, thank you. 380. I just want to make sure I have the right line number. Yes, okay. This bill makes it easier to gain a CPA licensure rather than having an extended coursework beyond 4 years of college. It allows for practical work experience to be counted as a alternate path to CPA licensure, while also preserving the existing pathway. The new pathway would allow candidates with a baccalaureate degree who have fulfilled the minimum hours in accounting and business to obtain licensure upon passage of the uniform CPA exam and completion of 2 years of work experience in accounting. They could enter the workforce sooner, earn a salary while working to become a CPA rather than incurring additional debt. Additionally, you have to get a baccalaureate degree plus an additional 30 credit hours of education and 1 year work experience, so it allows you to trade off the practical experience. This was brought to me by the Virginia Society of CPAs that endorsed the bill, and it's similar to what's happening in other states. There's a slew of other states that have done so already. It looks like about maybe 20 of them, but it doesn't, we'll still have experienced CPAs and maybe a little bit less college debt and more practical experience. And that is the bill.
Great. Thank you. Any folks in the audience that are opposed to Senate Bill 1042? Any of those in support that feel compared to give thumbs ups or go ahead? Yes.
Emily Walker with Virginia Society of CPAs. We do support this bill. Thank you to Chair Evan for bringing it. And of course, if you have any questions, I'm happy to answer them.
Great. Thank you so much.
Mr. Chairman.
We have one more speaker that's coming up.
Nancy Glenn, I'm the Executive Director at the Virginia Board of Accountancy, and we are in support of this bill and happy to answer any questions.
Mr. Chairman.
Senator Reeves.
I just had a comment that I think this is great because this also fits into what we're trying to do with military spouses that have CPA licensure, so it makes it a little bit easier for them to transition as well. So thank the patron for carrying it.
Okay, we have a motion and a second to report and re-refer Senate Bill 1042 to Finance as amended. Can the clerk open the roll?
Ayes 15, no zero.
Okay, next up, you want to take up Senate Bill 1043, and then you'll have Senate Bill 876 after that.
Okay, Senate Bill 1043, there's an amendment in the nature of a substitute I'd like to move.
There's a motion and a second on the substitute. All in favor of adopting, say aye. Aye. Substitute is properly before us.
Thank you. Thank you, Mr. Chairman. This is a cleanup bill. I consider it a cleanup bill. It requires a 60-day notice for non-renewals of a lease, which is already required in Virginia Code for people on a month-to-month lease or a manufactured home lease. It simply brings notice requirements for landlords, larger landlords, those that have more than 4 rental units, into alignment with those offering leases on a month-to-month or those in manufactured home facilities. It allows renters to plan ahead. Basically, if your lease is not going to be offered for renewal, you get a notice 60 days before saying it's not available for renewal.
Any questions of the patron? There's a motion and a second to report Senate Bill 1043. Clerk, open the roll.
Ayes 15, no zero.
That bill reports. And next up, Senate Bill 876.
Yeah,
Senator Evans.
there is a substitute. Apologies for all the substitutes, but I got a substitute on this one as well.
Okay.
Which I move.
All right, there's a motion and a second. Is it under amendment or a substitute?
It's a substitute.
Okay. All in favor of adopting the substitute, say aye. 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 Those opposed? Substitute is properly before us.
Thanks. This came to me from the Council for Open Government. It's designed to prohibit last-minute changes to meeting agendas. Under FOIA, you're supposed to have an agenda for what the meeting is in advance. And I'm just going to read lines 45 to 49 from the substitute, that the agenda, and which is required already, that there be an agenda available for inspection or published. But it says the agenda and any subsequent revisions shall be posted on the public body's official public government website, if any, and made available to the public prior to the meeting. Any items added to the agenda after the meeting commences may be considered and discussed at the meeting, but final action shall not be taken on such an item unless the matter is time sensitive. So basically, the public can't be blindsided. You can't hear that there's going to be a meeting on, as has happened, a meeting about the library board of trustees, and then they vote on railway easement agreements and relocation of county easements, or that you don't know that they're going to be considering a casino operator, and there's a mostly empty auditorium and little explanation. So we spoke to some local governments that had some heartburn over the original, or I don't know if it's VAC or VML or a local government, that had a little bit of heartburn over the original bill and came up with this, that you can add items to the agenda at the last minute and discuss them and consider them, but you're not going to take final action unless it's time sensitive. And that's the bill. It just makes clear something that should already be happening under FOIA, that if you have to publish an agenda, that it's actually an accurate agenda for what's likely to be considered.
Those in opposition to Senate Bill 876? Are those in support of Senate Bill 876?
Thank you, Mr. Chairman, members of the committee. Megan Ryan with the Coalition for Open Government, and I want to thank the chair for bringing this bill. We really are just trying to prevent citizens who may have decided not to attend a meeting because the agenda did not have items that they were interested in from them being blindsided from a decision that they would very much care about being added to it. And the example that the chair was trying to give was in Petersburg this past summer, where it was not on the agenda, but towards the end of the meeting, they added an item to scrap the RFP process for selecting a contractor for building the casino, and then voted to pick a contractor. That was not on the agenda. There were a lot of citizens who cared about it one way or the other. They were all blindsided. This is trying to prevent those types of situations. But we didn't want to tie the hands of local governments by not letting them react to time-sensitive opportunities, grants that might have certain deadlines. And so I also wanted to thank the local government folks, VML in particular, who worked with me on trying to get strike the right balance that is the substitute. Thanks.
And I just want to be clear, this isn't targeted at any one government. It's there are multiple examples. It's just to prevent it for the future.
And thank you, Senator. Senator Rouse, you have a question.
Just very quick. This doesn't prevent local governments from having special sessions either, though. So
no. But even in you mean having an emergency meeting or something?
No, special meetings can be called. I know in the city of Virginia Beach, 2 or 3 members can call, or even the mayor can call a special meeting.
Sure.
The very next day. So it may not be time to get the agenda out. You have to post what the special meeting is about, obviously, but it doesn't. This bill wouldn't prevent them from doing that.
No.
Okay, thank you.
Okay. Any other questions of the committee? If this bill reports, it needs to go to finance. All right, there's a motion to report and re-refer to finance. Clerk, please open the roll.
Ayes 14, no 0.
Thank everyone who testified for their relative brevity, but I wanted to tell the members we had about 101 bills assigned to us. We had about 35 on today's agenda, and a few went by for the week and so forth. So there may be a need for a supplemental meeting, and I just wanted to let folks know, I personally would prefer to meet on a Sunday evening to like a Saturday. So a week from this Sunday, I'm not saying we're definitely going to have a meeting, but I just wanted to let you know, and if you have heartburn about that, to let me know before we finalize it.
Not this Sunday.
Not this Sunday. There's a football game, and I don't think we need to. Yeah, and but maybe a week from this Sunday. We'll update you, and then stay tuned about the gaming subcommittee. You don't have a date yet, but it could come up pretty soon. Thank you, and I think with that our meeting is concluded.
Good job.
The Senate of Virginia, Richmond, Virginia.